Be cool, be kind, be classy. A cupcake so sweet and sexy. Have fun, enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives in New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Proctor and Michigas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcake's sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Happy Friday! Happy Friday, my friends. Today's Friday, October 24th, 2025. How's everybody doing? Wonder what else is going to pop off today. I'm sure there'll be some breaking news while we're here because that's what always happens on Friday, right? Well, today we're going to go over Kelsey Fitzsimmons' appeal to the full panel SJC. As you know, we've been covering that case very closely. And this single justice at the SJC denied Kelsey's right to appeal her bail conditions. And so now Tim Bradle and company and team have filed with the SJC for the full panel to review the decision. And so we will go through that. It's relatively short because there's a 10-page limit when you appeal to the full panel. And so we're going to talk about that. There was a hearing yesterday in family and probate court, and Kelsey was there at the hearing. Not a lot happened at the hearing, so there's not a lot to cover there. We will talk about it. We're going to look at the comments from outside the courthouse afterwards, which is also going to give us a little more insight into what happened in the court. I did watch the court feed. It was posted later in the day by our friends over at Justice Served. Great job sending Michael out there to, and he actually got a pass to be able to film inside the courtroom. But not a lot happened. There was a lot of waiting around. I have seen Justin's criminal background to 2013. Yeah, we've covered that before. Thanks, Dakota Girl. I think he had it was like possession of marijuana or something in New Hampshire. We covered that. And also this whole other situation that has landed on my desk several times with regard to former Boston police officer, and I think he got a promotion, and eventually he was like, had a much higher up position. Patrick Rose Sr. It's landed on my desk a number of times. It has now become relevant again because while the Mayor Wu has ran her campaign on eliminating qualified immunity, well, not really, because now the city of Boston is arguing qualified immunity on why they should not be held responsible for the horrific acts that Patrick Rose Sr. inflicted upon not only his stepchildren, but other children as well. And when you hear about this story, if you're not familiar with the story of Patrick Rose Sr., BPD, things like Sandra Birchmore will make a lot more sense to you, because it seems like from reading, I haven't gotten to read all of the filings, obviously, on this case, because it's been going on for a long time, but it seems like from what I'm reading that the Boston Police Department has been covering for predators since at least the 1990s. So there's that. He was president of the union. That's what it was. He did get promoted to be president of his union, even after these allegations surfaced in the 90s. And the things that BPD did and DCF didn't do, and what was hidden from the public that enabled this guy to go on and abuse more children after they were on notice of his behavior, is horrific. It's horrific. But it just puts into perspective a little bit more the good old boys club that's been going on for decades. Maybe cops covering for other cops. It's horrific. It's horrific. Yeah, it's not good. First thing we'll do is let's look at the comments from yesterday outside on the courthouse steps of Tim Bradel and the new family attorney for Kelsey Fitzsimmons. I think her name is Julie Hess. And it seems like during the hearing, the judge who was hearing the case started questioning Justin about where he lives, where he votes, where his car is registered, where he gets his bills. And apparently, if he's living with his parents now in Stowe, I keep thinking Stowe, Vermont, but it's Stowe, Massachusetts. It's a different county than where this is currently sitting, which is in Essex County in the Salem courthouse, correct? And so it seemed to me like the judge was confused about whether or not she would even have jurisdiction and whether the venue should be changed to the county where Justin actually lives now. And I think that is, correct me if I'm wrong, Middlesex, right? I think so. Okay, so let's take a look. Young Jerks, shout out to Young Jerks. They always let me use their stuff, so shout out to them. Give them a like and a sub. Mike was out there yesterday outside the courthouse, and he covered the comments on the courthouse steps. But it seems also like the parties have entered into a stipulation, meaning that they are in agreement about a lot of the issues and things that Justin filed for, but they can't really enter into the stipulation, and the court can't really so order the stipulation until she's convinced that she actually has jurisdiction. So the place where Kelsey lives, or lived with the baby, because now she's in Chicopee, was in North Andover, which is in Essex County. But Justin, obviously, I think she kicked him out of her house. I'm not sure, but they were not together, and he moved to his mom's house in Stowe. But they're going to give an excuse that when he first filed the papers, he was representing himself. He was pro se, so he didn't know which county to file them in. And so we are not sure if they're going to have to switch counties, but it seemed like all of the attorneys want to keep it in Essex County. So we're going to have to wait and see. All right. Shout out to Young Jerks. This is their coverage from on the courthouse steps yesterday after court. And here we go. The caption's on for you. If it's too low, let me know and I will boost it.
So we'd be more than happy to talk to everybody.
Okay.
We don't have to rush or anything. You guys mind if I just shift this way a little bit for the sun?
Do you mind if we start with Counselor Hess just on the probate stuff?
Yep, come here.
He's like, you got to get my good angle. You can only shoot me from this angle. I don't want the sun in my eyes. We love Tim Bradel.
I'm going to introduce you. Yep.
Thank you.
Everybody, this is Julie Hess. She's our family attorney, and Julie's going to talk about what happened today and where we expect to go with Kelsey and the custody visitation issues.
So today was a good day to finally give Kelsey a voice. We filed an answer. We filed a counterclaim. Today was really the day that she could really feel that she was heard and to start her voice in the probate and family court. We've already worked
That's Kelsey's new attorney. Her name is Julie Hess.
out some terms of an agreement that you probably heard the judge talk about, which is the stipulation. Both sides are willing to enter that wherever we may be. The judge currently is deciding venue. It's a big step in the case and it's a big deal, which is why I sought an extension of time to file a brief on that. And that's where we are right now.
I was going to say, see, you were kind of sandbagged on the venue issue. What's up with that?
I wouldn't say that necessarily. What happened was because before she could retain counsel to enter into the probate and family court, the clerk only could communicate with opposing counsel when they had filed a motion to expedite today's hearing. And that's when they alerted that attorney that the father had filed a certain document that indicated he lived in a certain place that wouldn't line up with the venue of this particular court. So the court had alerted him that that's what may be happening. And he did tell me this morning, and that's why we agreed on having an extension of time to address it. So that's something that we both have to look into.
Why does the venue matter? The attorney, Justin's attorney said he didn't ask for a change of venue or anything, but I guess just physically just in stone. Well, why does it matter?
Well, it matters because it's a matter of law. And so if there are orders that enter and it's the wrong venue, they could be easily vacated. So that's something that we want to make sure is settled. And when there is something that we need to have done, it's not going to turn on, oh, this person didn't have the authority to do that. So it's a big deal for both sides.
She's not going to say this, but I'm going to say this. Venue is a huge deal because there are friendlier counties than others. Some counties are more friendly than others. I don't know because I don't practice in Massachusetts whether Essex County is more friendly to, let's say, mothers in law enforcement, just for an example, than Middlesex County. But I will tell you that in New York, if you have, let's say, an injury case and you are looking for a big jury award, the Bronx is always where you want to be. The Bronx juries give out the most money. And it historically, it used to be that Suffolk County, New York was the cheapest. That's changing a bit, but venue is a huge deal. And it not just because the orders issued may be invalid, but also because some counties are better than others and some judges are better than others. And we've had our share of listening to the Superior Court judges in Essex County, in Salem, between Judge McCarthy Nyman and her, horrific attitude, and the recording of that court hearing that still haunts me, with Kelsey crying at the end of it when she threw her back in jail. And that is one example. And then the second judge that we heard on that same case who yelled at Tim Bradle to get down to the courthouse, even though the court clerk told Tim Bradle it was going to be on telephone. So there's that. Moving on.
Tell us a little bit about the venue. It's for the probate matter. Can you just give us a summation of what that's all, what's trying to happen with the probate matter, with the child and the house sale? And
No, I don't want to comment on that right now.
But
Long,
that's
long road. That's a long road with a lot of twists and turns.
But that's
you
the
guys
venue
know.
we're talking about for this.
For the probate and family court case, yes, absolutely. That's the venue issue that's before this court right now.
It seems to me there was a lot of pre-planning by Justin Lane, I'm sure I'm wrong. Got all of his ducks in order where he has his voting, his car, everything but his job. So I don't know. Do you think that's disingenuous to some degree or just overly planned? What's your take on how this was seemingly orchestrated?
I don't want to speculate. I also don't want to necessarily suggest it was orchestrated. I don't want to make too much commentary because, as you heard me say, probably to the judge today, there's going to be a lot of information I need to gather. And I do know that Justin's counsel is willing to provide me with the information that we need. So right now, I don't want to comment too much on that. But I will say it's not unusual for someone who is altering certain parts of their life to need to move on in certain areas. But that really does not affect venue per se after a case has been filed. Okay. Otherwise, I'm sure you can imagine most people going through a probate and family court matter might file something in one particular court and they make changes in the rest of their life. It doesn't affect venue. So I don't want to speculate too much on what Justin's motive may have been for doing any of that right now.
And so it sounded like you guys are going to brief the issue and the judge is just going to rule based on your briefs. You're
Yeah,
not going to come back for a hearing. And then what's sort of the next step after that once you settle on the venue, because the sale of the house is sort of right around the corner, it sounds like.
That's when the stipulation will be entered by the judge, the certain terms that we have agreed upon with opposing counsel and the father. Those are small steps towards trying to reunite mother and child. But that will be the next step. And then there's a lot of ins and outs that happen after these initial hearings. So we'll be working.
So it sounds like they're coming to some sort of an agreement on Kelsey being able to see the baby, right? That's what it sounds like to me. I'm going to take that back a notch, but it sounds like they're working on a stipulation that Justin is agreeing to somehow let Kelsey see the baby. Say that again.
The house is sort of right around the corner, it sounds like.
That's when the stipulation will be entered by the judge, the certain terms that we have agreed upon with opposing counsel and the father. Those are small steps towards trying to reunite mother and child.
Maybe.
But that will be the next step. And then there's a lot of ins and outs that happen after these initial hearings. So we'll be working on that for Kelsey.
What about the family? The grandparents don't get to see the baby. Is that going to come up soon?
That is not something that I can comment on. I do not represent the grandparents, and I have not even spoken to the folks who will be helping them. So I can't comment on that.
Everything's on the table, Mike. We're going to work on all those issues. Like I tell my clients all the time, we're still baking the cake on that. And sorry, Mike, sorry. So, everything's still on the table. We want to get Kelsey and Caden to a proper place. It's a bit of a road and there are some hurdles. As everybody knows, there were some hurdles also interposed by the Superior Court judge that we're going to have to address. And we are addressing those soon in this SJC. We're going to be filing today our petition in the SJC full bench requesting that Kelsey have a completely new bail structure put into place. And we're filing that today. We expect that, and we're optimistic that there's going to be a very short turnaround time. There's going to be an expedited hearing. We're asking for an in-person hearing. Those don't often happen, but I think this case certainly warrants it. And that's part of the overall picture that's going to be important for Julie to best address Kelsey's situation. We have to get that bail situation dealt with, which will, we hope and expect, will remove some hurdles that are in place for Kelsey's reunification.
What opened the door for you to be able to do the full panel? You said there's maybe an error about the single judges?
Yes, we're contending there's an error of law, and I'm going to let the papers speak for themselves. And I promise you guys will have them when we file. So,
How is
We've got the papers. We're going to look at them after this.
Kelsey doing? How is she
she's
feeling?
doing great. She's very happy that, she's here in probate court. Julie's given her a lot of hope that things are going to finally move relative to Caden, which of course is the most important thing to her. I said in a few of my filings a while ago, Kelsey's devoted her entire life to two things: her baby and her law enforcement career. And she's gonna keep her eye on the ball, and we're gonna get her there.
Did she get any help from her police union on the defense or the probate matters or anything?
We don't want to get into that right now. That's another thing that's on the table, and that's something that's in the works. We have some excellent counsel on that as well, and we fully expect that's going to land in a place that's appropriate and happy, and Kelsey will be happy with where it lands.
And the focus of the criminal case is really just figuring out where she was pointing that gun. It seems like that would be the tell of where this case could go, or it would be thrown out.
That is the crux of that case, and that's going to be dealt with hopefully in short order.
How do you approach that? That's what I was trying to.
Not going there.
Is this the first time they've seen each other since the restraining order?
Wait, I got a stereo.
One question, guys.
Is this the first time that Kelsey and Justin have seen each other since the restraining order, the shooting, all this went down?
Right. That's true, Charlie. It's a tough atmosphere, but she's going to be fine. She's going to be great.
What did she say after? How she was feeling after today's hearing?
She's up. She's encouraged that things are moving along. She's very happy to hear that we're going to be getting some. We're going to be heard in the Supreme Judicial Court very soon. We're very optimistic about that, and she's above all, she's just thrilled to have Julie on the case, pushing her rights here in probate court.
And what?
Happy to show up for her son today. I think she feels like she shows up for herself and her son when she does this. I think that's why she felt hope today.
Can you speak about her supporters showing up and how
That's what I want to.
to look out the gallery and see everybody in purple or?
Sure. She actually asked about that. She said, who is here today? And we explained to her all of our supporters were here today and that everyone was here to help her. And she was very elated to hear that. Can you elaborate on that?
Yeah, she really appreciated that, and I'm glad you said that, Amanda, because she did ask me to tell you guys, that She really appreciates everyone being here, taking time out of their lives to support her. It means the world to her. It means the world to us. So thank you.
Yes, thank you.
Yes, so let me ask you about the stipulation. Let me squeeze in here.
Yeah,
Go ahead. Anything you can share about the stipulation,
That's Michael from Justice Served.
and was it filed, and if so, under seal or not?
It was filed. I don't want to share too much because the judge declined to issue an order on it due to the venue issue. I will say that the provisions that are in the stipulation are moving toward a reconnection with her and her son. It's positive steps. And I'm happy to say that both sides were on the same page for that, literally and figuratively. So that's all I can say on the stipulation.
So there you go. It is sealed. I can't get it. I did get a copy of her answer. We're going to go over a copy of Kelsey's answer, but it seems like she said both sides seem to be on the same page. And like Mass Dad says, he's your guy. If you have questions on Massachusetts procedure, regardless of what's going to happen, it's going to take a long time. Even if she's freed from custody, she won't be able to see the baby right away. But it sounds like they're entering into a stipulation, which could change that. And that's why probate court matters are not quick, but most of them are resolved by stipulation. And so that is a good thing because that will get them a quicker resolution than waiting for the court to decide on anything at this point.
On the funds for the sale of the house, ultimately, are they going to go into escrow to be decided later? I realize now with the home sale pending and imminently, you got to figure out where that money's going to go. Is some sort of escrow a likely possibility there?
TBD, to be determined. We don't want to get into details. Like Julie said, she's trying to bake this cake. So let's just let it play out. And, stipulations are proposals to the court and we'll see what happens. But we'll have to wait and see.
Is that why the venue kind of matters? Because of maybe where the money might land?
No, that's not really
Okay.
what
Yeah.
Six.
Next hearing.
When do we get to?
Is it October 29th?
The next hearing in the restraining order or in the probate and family court matter?
Either or in both.
Probate and family will be in May, but there's likely going to be hearings before that. But that's the next scheduled hearing for the restraining.
May. That's a long time. We're only in October, my friends. That's why stipulations are the best because the next hearing isn't for 7 months unless there's an emergency hearing that comes up in the meantime.
Restraining order, I believe that's in November.
December 2nd. November 20th.
December 2nd.
December 2nd.
December 2nd, Courtney, thank you. December 2nd
And criminal is
is,
25th
is,
November.
no, what's the criminal?
There was one on the 25th of November.
It might be.
November 25th is Salem Superior, Essex Superior. However, the restraining order at probate is December 2nd. So November 25th for.
November 25 over there.
Okay.
December 2nd here for the restraining order.
Can we ask the parents how they're doing and they're here and they're supporting?
I think guys, they've been through the ringer, they've been here every step of the way. They've been supporting us in 100 different ways, supporting Kelsey. They're taking their cues from us and, they kind of want to speak through us for now. And, other occasions, maybe, in a less kind of on the spot way that they'd be willing to speak with you guys and just let us know when you want to hear something like that. We'll work with you on it.
Thank you.
Thank you.
Yes.
JULIE and then HESS.
Yes, sir. Yeah.
Everybody good?
Thanks, sir.
All right.
Thank you.
Thank you.
Thank you for being here.
Just on my
Good to
own,
see
not on camera.
Thank you.
It's,
Good to see you, Mr. Bradle.
Kind of the stipulation, what is trying to be sorted out in the whole case right now? It's basically, who has the custody of the child, and is that kind of what the whole case
All of that is
is?
going to be addressed in this court, but
Gotcha.
it all takes a lot of time to flesh out.
Got it.
So custody, parenting time, child support, health insurance for the child, that kind of thing. That is all going to be part of this case.
Got it. And then this court, does they weigh in at all when that sale happens? That's not involved at all. Okay. That's why I was confused. Like, there's something I don't there. That, like, that's impacting the house sale. Because she was saying that she was trying to get it done before the November 7th.
Hey,
and I mean,
thanks
so
for
that
coming.
there may not be a
Yeah.
extension.
Once you see the stipulation, you will understand, but I can't really reveal more than that right now.
Gotcha. And you see the stipulation, I can't see the court, right? It's going to be at the clerk's office or?
I'm not sure what the judge did with it. She probably is holding it.
Okay. Thank you for.
Thank you.
I covered criminal only.
It's a whole different atmosphere, right? Whole different ballgame.
Do you mind if I, do you have your contact number or anybody?
Sure, I'll give you my cell, 617.
Yeah.
Well, I won't be here on November 25th.
We need us, yeah.
Yeah.
When do you think we'll see the actual SJC thing?
I
Before?
might need to eat a turkey sandwich first.
Oh, yeah,
I'll put it out.
So that's my two, but maybe it's my four.
I promise everybody will get it.
Okay.
Somebody doesn't have it by.
Yeah.
Would have been better if he said he had a ham sandwich.
Thank you. Sorry. Thank you. Great job.
The extra tall attorney may be an associate of Julie
And I'm
Hess,
gonna,
but he was inside the courtroom as well. I'm not exactly sure who he works for. It would have been better if he said a turkey sandwich. I mean, a ham sandwich. Jenna says it sounds really hopeful. It does sound really hopeful. That's a good thing. Agreeing on things rather than letting the court decide your future is always a better thing. Sarah says Julie Hess is a boss. Let's take a look at the answer that was filed on Kelsey's behalf. What's today? What did I say today was the 24th? This was filed on the 22nd. Remember, the original complaint was for custody, child support, and we have about, I don't know how many shows, a lot of shows before this one. And we went over all of the pleadings in detail. So here's the latest one. Julie Hess's associate. His name is Ryan Leonard. Thank you, Mass Dad, because Mass Dad knows everything. Thank you. Here we go. Oh, look, it's your first live. Everyone, welcome, Paul, Terry. It's his first live. He never misses an episode, but it's the first time he got here live. Happy Friday. Happy Friday. All right. This is the answer. This is the assented to motion to file, answer, and counterclaim late. Typically, most jurisdictions, you have 30 days to file an answer, unless you get an extension from the other side. But circumstances may have made it impossible for Kelsey to answer, being that she was in the hospital and then she was in jail, where she still remains. She was allowed to go home for like maybe 48 hours before the judge threw her in jail again. Well, let's take a look and see what it says. This is Justice Alian versus Kelsey Fitzsimmons. Answer the assented to motion to file, answer, and counterclaim late. Now comes the defendant, Kelsey Simmons, hereinafter mother, in the above captioned matter, and moves this honorable court to allow her to file her answer and counterclaim to plaintiff Justice Alian's amended hereinafter father's amended complaint for custody support parenting time filed August 8th of 2025. As grounds, mother states as follows. 1, mother's counsel encountered significant difficulty in communicating with mother during her time in the hospital and detention facility. Number 2, the difficulty in communicating with mother impeded counsel's ability to properly enter the case and communicate about the client's needs. Number 3, mother will be prejudiced if unable to file an answer and counterclaim. And number 4, father will suffer no harm or prejudice in the late filing. Wherefore, so this is actually a motion to file a late answer. It's not actually the answer. Hold on. But Justin's attorney has agreed and he has signed off on this as well. That is a good sign. It is a good sign when attorneys can get along. Most attorneys have been working against each other for decades. And so they have a good working relationship. And that is always a very nice and positive thing to see, because his attorneys could have been real jerks and said, no, we want a default judgment. You didn't answer on time and we want it all. But they're agreeing to allow it. And so hopefully this judge will allow it, but she can't allow anything until the venue issue is straightened out. So that is one thing that we can go over today that looks like a positive sign. Let me just go to the questions for a quick minute, and then we will go to the appellate papers. Holly Johnson says, I finally caught your show live again. Thanks, Holly, for your $10 super chat. I appreciate you so much. And Jojo, thanks, Jojo, for your 5. Says, in my opinion, I think it's way back farther than the 90s, the late 60s and 70s, maybe. Yeah, as far as the cops covering for other cops in the Boston as such area. Did anybody watch? What was that show with Kevin Bacon? There was a show with Kevin Bacon about Boston corruption in like the 70s. Jill Hennessy played his wife. What's the name of that show? City on a Hill, I think it's called. It got canceled, I think. I don't think it's on anymore, but that is exactly what it's about, right? City on the Hill. Right. Thank you, Jojo, for your super chat. And Vicky says, I love your earrings. Oh, thanks. You know what? If you like them, I'll link them to the show. So if you want to buy them, there'll be a link there later. Betsy says, God love you, Mel. Another day of doing the Lord's work. I love you with all my heart. I love you too. I love you too, Betsy. Thank you. Teresa, I saw this come up, so I started. Justice Served has offered to pay for alternative scram testing if allowed by the courts. I know. That was so generous of them and really nice of them to say that they would pay for the scram monitor, because we looked at the scram website. They do have a monitor that will monitor alcohol intake via ankle monitor every 30 minutes or something through perspiration, but they don't use that one in Massachusetts. And so while I think it's a very generous offer and such a great idea and so nice of them to do, it is my opinion that this court won't allow it. I don't know. Mass Dad, you can let me know what you think, but I think the way we've seen things play out so far with Kathleen McCarthy-Nyman, and, you know, we've seen other judges too, like that's not the way we do it in Massachusetts, Mr. Jackson. We've seen this film before. Do I think she would make a special exception for Kelsey? I mean, she wouldn't even make a special exception for Kelsey to not have to breathe into that thing. So I don't have high hopes for that, but I think it's a wonderful thing that they're agreeing to do. So there's that. Look at Cheech says, City on the Hill, they wanted to use my house for the show, but by the time Al called him back, they found another house. Yeah. You got to jump on it. You got to jump on it quick. But I would never, unless they are only doing exterior shots of your house, I would never recommend allowing a film crew inside your house, no matter how much money they offer you, because I've seen it. I've seen what happens to your house afterwards, and it's a huge imposition unless you're not living in it. But, you know, you might be lucky, because the amount of money that they pay you is not enough for the amount of damage that they can possibly do. Jennifer says Massachusetts was definitely corrupt in the 70s. Yeah, so we say, so you guys say. All right, moving on to, and I'm sorry because the only copy that I have of this document is like a JPEG, and so it's a little bit fuzzy. But, you know, you get what you get and you don't get upset, as they say in preschool. And so I will read it to you. Don't worry. If you're looking at your TV and it looks really blurry, it's not your eyes. It really is. This is the Supreme Judicial Court Rule 221 appeal from interlocutory order of single justice for errors of law and abuse of discretion. And this is on the Commonwealth versus Kelsey Fitzsimmons matter. In our society, liberty is the norm, and detention prior to trial or without trial is the carefully limited exception. Although the federal Constitution and the Massachusetts Declaration of Rights do not prohibit pre-trial detention, they permit it only in carefully circumscribed circumstances and subject to quite demanding procedures. This traditional right to freedom before conviction permits the unhampered preparation of a defense and serves to prevent the infliction of punishment prior to conviction, unless this right to bail before trial is preserved. The presumption of innocence, secured only after centuries of struggle, would lose its meaning. The practice of admission to bail, as it has evolved in Anglo-American law, is not a device for keeping persons in jail upon mere accusation until it is found convenient to give them a trial. On the contrary, the spirit of the procedure is to enable them to stay out of jail until a trial has found them guilty. Without this conditional privilege, even those wrongly accused are punished by a period of imprisonment while awaiting trial and are handicapped in consulting counsel, searching for evidence and witnesses, and preparing a defense. And I love this piece of legal writing because the entire half of the first page is a quote from a case entitled Brannigan versus Commonwealth, and it's a 2017 case. Introduction. Oops. Now comes the petitioner, Ms. Kelsey Fitzsimmons. Okay, this thing's going to make me crazy. Hang on a second. I have to go back to the original, the way it was, because otherwise it's going to keep being all fakakta. Hold, please. Okay. Introduction. Now comes the petitioner, Ms. Kelsey Fitzsimmons, held without bail and invoking the foregoing principles, and hereby appeals the interlocutory decision of the single justice. She proceeds pursuant to SJC Court Rule 221 and asserts that the single justice applied the incorrect abuse of discretion standard of review. The single justice declined to reach, under the proper de novo review standard, the merits of Ms. Fitzsimmons' case as a person deserving of a traditional release on bail or recognizance. The interlocutory order of the single justice was thus based on an error of law and abuse of discretion and must be vacated by the full bench, which should also decide the bail issue and release Ms. Fitzsimmons. Petitioner was before the Superior Court on only one count of assault by means of a dangerous weapon, a 5-year felony at the very bottom of the threshold for Superior Court jurisdiction. Footnote 2. The Commonwealth sought an assault with intent to murder charge, but the grand jury just declined to indict. She is eligible under the proposed sentencing guidelines for a probationary sentence. She is a police officer and former corrections officer. At the time of her incarceration, Ms. Fitzsimmons was at liberty and on release under 58A terms. However, the Superior Court layered many excessive demands on petitioner. She was placed on a GPS bracelet, house arrest with almost complete lockdown, accepting medical and lawyer visits, but only with 48-hour notice, required to abstain from alcohol use, and required to blow into an alcohol sensing device referred to as a scram monitor, stay away from the responding officer who shot her in the chest, and a stay away, no contact order from her own baby, regardless of the probate and family court orders. It became quickly clear after only a day that petitioner could not constantly blow into the device without severe pain and dizziness. And she returned to Superior Court in good faith on her own motion, seeking assistance and a reasonable accommodation, all with the support of her probation officer. Footnote 3. See the brief. Instead, but we know because we were there, that it was the Assistant Chief of Probation, Mr. January, who testified that Kelsey was not in violation, that he would not have violated her, that he saw her when he tested out the device with her, he saw how painful it was, and that he believed her. Judge McCarthy Nyman, on the other hand, did not want to believe a thing that he said. And actually, I think he even said so in her decision, right? Instead, without a request for surrender from either the Commonwealth or probation, the court revoked the release plan and without notice put Ms. Fitzsimmons into custody for 180 days. Footnote 4 also says, see the brief. The court then walked off the bench, ignoring counsel's argument for reasonable accommodations, alternative testing means, urine testing, and the required least restrictive terms of release under 58A. We heard that too. We heard them shut off the tape recorder. We heard him ask to keep talking. We heard Kelsey crying in the recording. And those are all things you're not going to see in the transcript. Only in the recording will you hear that, right? So I don't know if the single judge listened to the recording or she just read the transcript, but I submit to you that I think there's a big difference. Because you may not hear the things that Mr. Bradle said after they shut off the tape recorder and the judge walked off the bench to try and be heard. Rule 221. Supreme Judicial Rule 221 allows a full bench appeal of unreported interlocutory orders by a single justice. The rule limits briefing to 10 pages and confines the new pleading to addressing reasons why review of the trial court's decision cannot be adequately obtained on appeal from a final adverse judgment in the trial court or by other available means. Here, Ms. Fitzsimmons has no ability to obtain alternative review of the underlying trial court's bail decision, left undisturbed by the single justice, finding her to be a danger, revoking her release without notice, and holding her without bail. The nature of a bail decision incarcerating a defendant pretrial constitutes a real-time intrusion on her liberty interest that cannot be addressed or remedied in the future in a direct appeal. It is axiomatic that bail decisions must be speedy if they are to be effective, and the bail review framework etched into the common law by this court in Camesso, Chisholm, Brangan, Infra, and their progeny mandate review and a de novo decision, which means they should look at it fresh. The full court's review of a decision incarcerating a defendant while awaiting trial will be focused on whether the detention decision was truly rendered only in carefully circumscribed circumstances and subject to quite demanding procedures. Citing Brangan, errors of law in connection with review will be remedied by this court's own independent determination of the law and its application to the case at hand without deference. The erroneous intrusion on petitioner's liberty interest cannot be restored at a later date through the appeal of a final adverse judgment or by any other available means. And those are the reasons why this should be decided and heard quickly, because it can't be remedied later after she's already spent the 180 days in jail. In-person hearing request. The petitioner respectfully requests that the court grant an in-person hearing and hear oral argument in the matter. The case involves a large body of evidence amassed in favor of Ms. Fitzsimmons' release that has gone unaddressed in the prior reviewing courts, that petitioner asserts is determinative in favor of release and should be considered and noted in person before the court. All right. High hopes for oral argument, because we've been watching a lot of them lately in appellate courts, and they're interesting. Expedited hearing request. Petitioner Fitzsimmons respectfully requests that the case be heard in any possible expedited fashion. The Commonwealth was given 6 days to respond in the single justice session and was able to comply with that order. Further, the inherent risks to an incarcerated police officer and former corrections officer, her ongoing recovery from a gunshot wound to the chest, and the separation from her now 8-month-old baby are compelling reasons entirely beyond the lack of legal justification for the order for an expedited hearing. I've pointed this out before, and I'm going to say it a little bit louder for those in the back, that any parents who have ever had a child, the developmental milestones and the changes in your baby between the ages of 5 months and 8 months are incredible. And the fact that she has been without her baby for well over 100 days, something like, I don't know, over 120 days at this point, I think, is so wrong, in my opinion. She was breastfeeding her baby. That bonding time is essential, I submit to you, and it should not be tampered with. Even if you believe that Kelsey needs to be incarcerated, there are still avenues by which she can be allowed supervised visitation with her child in jail. And so this whole thing is just so horrific to me. Footnote 6 says, undersigned counsel proffers that Ms. Fitzsimmons had to cancel what would have been her 5th surgery when the trial court refused to allow her to have her bracelet potentially cut off for the operation. Do you remember that? The day that the court finally agreed to release her, because we thought she had initially been released, and they reported to the media, and a lot of mainstream media reported that she had been released. I think it was on August 28th. And then the court took extra time, like maybe 10 days longer, to run criminal checks and stuff on the people that she was going to be living with, and then didn't actually release her until like maybe the second week in September. And I remember it was a Monday because she was supposed to have surgery the next day. And Tim Bradle said to the court, Your Honor, would it be okay? She's got surgery scheduled tomorrow. Could we come into probation after the surgery and have her ankle monitor installed then? Because I don't think a doctor is going to do the surgery with the ankle monitor. And the court and the judge, McCarthy and Nyman, just said, no, you can't. And so she did not have that surgery. And I think that was a surgery for her liver, a lacerated liver. I thought that was going to be her 6th or 7th, but here in the papers, it says it would have been her 5th, which means she had 4 surgeries while she was in the hospital after she was airlifted from the scene of the shooting on June 30th and spent 53 days in the hospital She was arraigned in the hospital until she was transferred to jail. Request for relief. Ms. Fitzsimmons respectfully asks that this court, 1, address the bail determination de novo consistent with the applicable case law referenced in her single justice brief. 2, grant Ms. Fitzsimmons an appropriate release decision for a police officer charged with 1 indictment, a 5-year felony for which she qualifies under the guidelines for probation, personal recognizance, and a stay away order under Section 57, no finding of dangerousness required, or additional conditions under Section 87, bail terms imposed with agreement of the defendant of Chapter 276, or grant such other non-incarcerative relief in the alternative if the court deems 58A conditions necessary, and send the case back to the Essex Superior Court before a different judge for the reasons set forth in petitioner's single justice brief, which we did go over. They're asking McCarthy Neiman be taken off the case. Hang on one sec. Everybody don't forget to hit the like button. Hit the like button while you're thinking of it. Thank you. Standard of review on orders of the single justice and the trial court. The petitioner requests that the full bench review and decide the issues set forth before the trial court and the single justice. See Comesso, which says the full court has jurisdiction to review on exceptions, report, or appeal questions of law arising in a bail determination by a single justice under Section 58. This court further set forth the framework for its review of a single justice bail determination in Chisholm versus the Commonwealth as follows. When a party appeals from an adverse judgment by the single justice under General Law 211 sub 3, we review the single justice's order for clear error of law or abuse of discretion. We must also consider the propriety of the Superior Court judge's underlying bail order. And then this is in bold, this next sentence. In reviewing both the single justice's judgment and the bail judge's order, we must consider the legal rights at issue and independently determine and apply the law without deference to their respective legal rulings. It's so blurry that I don't know where footnote 7 was in here, but footnote 7 says, Ms. Fitzsimmons respectfully submits that it is imperative for this court to listen to the recording of the trial court bail hearing. I didn't even know, this is a cold read. I didn't know he was going to say that. Which recording is Exhibit 1 of single justice petition. The single justice apparently only reviewed the transcript later provided by the Commonwealth and was not able to appreciate the egregious treatment of the defense and the probation department, which is made clear by listening to the hearing culminating in the judge departing the bench while defense counsel was mid-argument. Great minds think alike. No reasonable listener can reach the conclusion that the court approached the matter impartially. It's imperative. See also Comesso providing a further basis for jurisdiction. Moreover, a demand for excessive bail would violate Article 26 of the Declaration of Rights of the Constitution of Massachusetts. Compare the 8th Amendment to the Constitution of the United States, which has been assumed to have application to the states. Next section is called Trial Court Ruling. Here, as amply set forth in the petitioner's single justice brief, the trial court's decision was infected with errors of law, misinterpretations of the record, and unexplained hostility toward the defense team and the probation officer who is testifying in favor of the defense's position. The defendant is not dangerous. She is a dedicated and conscientious police officer, and she adamantly denies that she pointed a gun at the responding officer. She has no alcohol problem, and the incident had absolutely nothing to do with alcohol. There is no ongoing future potential danger to the responding officer who almost killed her that could justify a finding by clear and convincing evidence that no conditions of release are available. The officer saw a gun and fired, and by claiming petitioner pointed the gun at him, all his problems go away. Bradle is telling the SJC everything, says Michael L. And yeah, I'm going to read that again for emphasis. The officer saw a gun and fired, and by claiming petitioner pointed the gun at him, all his problems go away. Ms. Fitzsimmons was only a danger to herself, and using deadly force on someone who only exhibits a danger to themselves is unlawful in the Commonwealth. An officer may not use deadly force against a person who poses only a danger to themselves. That is citing a statute, 555 CMR 6.053. This court is empowered to apply its collective trial court experience and knowledge to consider the legal rights at issue and independently determine and apply the law without deference to their respective legal rulings. In using such collective experience, there is no reasonable scenario in which Ms. Fitzsimmons should be held or be subject to the panoply of harsh conditions imposed by the trial court. No justice on the instant panel would impose such conditions and then incarcerate petitioner as a result of a serious health issue, making compliance torturous and painful. Single justice ruling. The single justice's ruling was also based on an error of law. As set forth above, the justice was required to review the matter de novo and decide the bail issue. Instead, the single justice only examined the trial court's actions under the much narrower abuse of discretion standard, and in any event did not appear to examine the propriety of the bail issue itself at all. The single justice appeared to be solely focused on whether General Law 276-58A4 applied over Section 58B as the proper interpretation of what transpired in the trial court. The justice also gave full abuse of discretion deference to the trial court's 58A finding, the harsh conditions, the surprise incarceration, and the completely unnecessary adherence to the at-home scram breath test. The decision also ignored the application of the Americans with Disabilities Act and the opinions of 3 experts, a psychiatrist, a psychologist, and a licensed social worker, all opining that petitioner is not a danger. The reviewing court also ignored readily available reasonable accommodations, such as the urine testing option, or categorizing a urine test at a facility to be a medical visit fitting under her rubric. Under the proper standard of de novo review, a reasonable judge would perceive the necessity to comply with the Americans with Disabilities Act, as well as the 58A requirement to impose the least restrictive alternatives and allow Ms. Fitzsimmons to travel to a nearby urine testing facility, Aver Health Industries, a Commonwealth vendor that routinely provides this testing service just 10 minutes from the petitioner's residence. Certain times I feel very heard, and this is one of those times on page 7. Footnote 8 says, see petitioner's brief, pages 17 to 21, and footnote 9 that says, after the surprise incarceration order, as the defense was seeking to be heard further, the court walked off the bench in the middle of counsel's presentation, prematurely ending the hearing and preventing counsel from fully addressing the reasonable accommodations and the least restrictive alternatives. Probation also utilizes in-home visitation from Commonwealth vendors who can come to the house and administer tests that are sent to the probation officer. A reasonable bail determination would also not include complete lockdown, GPS bracelet, and 48 hours notice for medical and legal visits only. The incident before the court had nothing to do with alcohol use or abuse and does not justify the rigid demand for only a certain type of alcohol testing over another type that can serve as a less restrictive alternative and reasonable accommodation under the ADA. Footnote 10. There is no evidence in the record that scram monitoring is more or less precise than other types of testing, or that any testing is superior to another. The court should have further inquired of probation as to the many other options available and not simply abandoned an examination of the least restrictive alternatives and locked her up. Conclusion. For the foregoing reasons and the reasons set forth in the petitioner's single justice brief and exhibits, the court should vacate the order of dangerousness, grant the petitioner release on personal recognizance with a stay-away order, and remand the matter back to the Essex Superior Court before a different judge for further proceedings in the case or other such relief as requested above. XOXO, October 23rd, 2025, Timothy Bradle, Esquire, and Martha Coakley, Esquire. With a certificate of service. So the crux of this argument is the one judge panel's job was supposed to be to look at this whole thing with a fresh set of eyes and make a brand new de novo determination about the bail conditions, not to just look at what the trial court judge did and decide if she abused her discretion. They were supposed to look at it anew. And the single justice did not do that. And therefore, full panel, you should please hear our prayer. And so, MassLive, if you're here, do they have the option to say, no, we don't want to hear this? I think they do. But because the standard by which the single justice decided this is wrong under the law, it is a legal question. Tom Gully says, fresh eyes will be needed at 10:15 Eastern for Colorado versus Utah. Is it tonight? I thought it was tomorrow night. Hold on. Let's go Buffs. Let's get some Buffs emojis in the chat, can we? Shall we? Let's go Buffs. Last year was it's tomorrow at 10:15 p.m. Thank you. 10:15 p.m. Eastern. I think I was the last year's game that I went to was against the Utes. And I was wondering why I was able to get such a great ticket on the west side of the stadium, which is the sunny side of the stadium because it was a day game. And so you always want to sit on the west side of the stadium. Pro tip, if you go to Folsom, because it stays sunny and it was hot. And I think they played the Utes. I think it was. And I was wondering why I was able to get a ticket for like $100. That was like so close to the field. And it's because I was sitting in enemy territory. But that's okay. It was okay. They were very nice. there were some Buffs fans sitting around me where I did. News clip, Boston 25 just reported Proctor is in trouble. Like on Boston 25's, like sometimes they upload their clips to YouTube late. And so it could be something from like 2 days ago that they're just uploading now. I mean, he is in trouble, but I don't know if he's in any new trouble. Or sometimes if you're watching YouTube and you get an alert pop up, it's because they're just, finally reporting on something from like 2 days ago. All right, well, let's see. Let's see, D. We're so collaborative here. And, we're able to pivot to the breaking news. But I don't see it on the landing page. If you want to email me the link to the news article, I'll take a look. But what I will tell you is that Brian Walsh, they've asked for an extension to hold him at Bridgewater State for a longer period of time. And there was supposed to be a competency hearing on Monday. That has been pushed. And the Judge Frenier, has allowed it. So there will be no hearing on Brian Walsh on Monday. There are a number of new filings on Brian Walsh. However, they're asking for a trial date in late November right now, the Commonwealth. So that's going to depend on, first of all, the competency evaluation and determination. And so the motions in limine are not as time sensitive to go over the responses, but if we have enough time today, we can do that. I do have them in my inbox. Let me just do a quick search here on the homepage because I don't see nothing's popping up like on the front page about Proctor. So I don't know if it's new, old, or what. Thoughts, questions, comments, concerns before we move on to whatever our next topic is going to be. Thanks on top for your super sticker. And thank you, Brigitte, for upgrading. I saw you said you upgraded your membership to floor seats. Welcome. All right. It looks like, thank you, Emily C. It looks like Kelsey Fitzsimmons' mom did an interview with MassLive, and that was published early this morning. Let's take a look at that. So while we are still on the Kelsey topic. I'm sorry, it wasn't Emily C. It was another Emily who sent that to me. All right, let's take a look. And it's an exclusive for MassLive. Kelsey Fitzsimmons' family describes life since daughter's shooting and arrest. This is just published today. Kelsey Fitzsimmons and her fiance spent almost every Sunday night with her mom and stepdad. After Fitzsimmons gave birth to her son in February, Lauren and Will Page hosted Sunday Fun Day, where the family, including Page's kids from a previous marriage, would gather for dinner. We would have a full house, and this went on for a while, Will Page told MassLive in an interview on Monday evening. But the Pages began to notice some tension between Fitzsimmons and her fiance, and the couple missed several Sundays in a row, which struck them as odd. Something's not right here. Not long after those visits stopped, everything changed for Fitzsimmons and her family. On the last weekend in June, Fitzsimmons and her fiance went to Maine for a bachelorette party ahead of their wedding, which was scheduled for this month, a date that has since come and gone. I think it was supposed to be October 4th. On the night of June 28th, Fitzsimmons' fiance claims she got drunk and assaulted him, hitting him 3 times with her fist. The next day, according to Fitzsimmons' fiance, she sent him disturbing text messages, including one where she said she was going far away for a long time and that neither she nor the minor child was okay, according to a court filing. And if you've been following my coverage on that, you know that we went over this court filing. Those were Justin's. Some of them were handwritten, I think. I think that was his initial application for the restraining order. Or the custody petition. Now I can't recall. On June 30th, as both Fitzsimmons and her mother tell it, the couple were supposed to meet on the North Andover Common to reconcile, but Fitzsimmons' fiance never showed up. Right, remember she waited there in the park for like 3 hours? Instead, he obtained an emergency restraining order at Essex Probate and Family Court based on an affidavit he submitted where he claimed Fitzsimmons had threatened the life of their son and repeatedly assaulted him. In a filing supporting his bid for full custody of the son, the fiance claimed Fitzsimmons had behaved erratically in the past. He accused Fitzsimmons of punching herself in the stomach while pregnant on a trip to Croatia last October and claimed she threatened to kill herself on multiple occasions. Tim Bradle, a lawyer representing Fitzsimmons in the criminal case, said after a court appearance that the affidavit was full of self-serving allegations. Her whole world was taken away from her because a guy went to the probate court and filled out a piece of paper, he said. From Fitzsimmons' perspective, she's left with more questions than answers about her fiance's actions. Why, Mom? Why would he do all that? Lauren Page recalled her daughter asking. When police arrived at Fitzsimmons' home to serve her the restraining order, an officer shot her in the chest. What led up to the shooting is at the heart of the criminal case pending against Fitzsimmons in Essex Superior Court. Did she, as police say, point her weapon at an officer and try to fire it? Or did she attempt to take her own life, as she claimed? Fitzsimmons is charged with assault with a dangerous weapon. A grand jury took a wrecking ball to the case, Bradel said, when it declined to indict Fitzsimmons on a charge of armed assault with intent to murder. Family speaks out. It's been a difficult 4 months since the shooting for Fitzsimmons' family, as she spent months in a Boston hospital before being moved to the Western Massachusetts Regional Women's Correctional Center in Chicopee. It's been no real highs this year, Will Page said. It's all lows. Kelsey is feeling it worse than we are, but we're getting beat down just as bad. The Pages have filed a petition for visitation rights with their grandson, who they haven't seen since the night in June when Fitzsimmons was shot. In the last 4 months, they've received just 2 photos of the boy. It was June 30th. That's been particularly hard for Lauren Page, who said she barely went a day without seeing him before the incident, frequently stopping at Fitzsimmons' home on her way back from work. I couldn't go more than 2 days without seeing the babes, she said. Kelsey would feel better knowing that he's with us because we spent so much time with him. I'm mad, added Will Page. Oh, here's a picture of them with the baby. Look at the baby. Yes, the officer that shot her is still on the North Andover Police Force. Kathy, his name is Noonan. Still, they are buoyed by the growing support for Fitzsimmons online. A Facebook group titled Justice for Kelsey Fitzsimmons official group has amassed more than 3,000 members. At the last court hearing in the case, about a dozen supporters showed up wearing purple, some with t-shirts calling for justice for Fitzsimmons. Posts in the group mostly urge Fitzsimmons to stay strong, while others work to organize fundraisers or events to help support her. Support for Fitzsimmons grew after a hearing in September where a judge reversed her order granting Fitzsimmons release and sent her back to jail after finding she could not comply with court-ordered alcohol testing. It's keeping her going 100%, Lauren Page said about the public support for her daughter. She's getting letters from all over the world that she reads at night, and it helps her to know that this is a bigger fight. Oh, that chokes me up because all you guys are writing letters. The address, if you want to write to Kelsey, is in the show notes below this video. There are very detailed instructions that are not in the show notes here, but if you go back to one of the prior Kelsey streams, there's a whole entire playlist on Kelsey. You will see the details of instructions of what you're allowed to mail and what you're not, and what kind of ink you have to use, and what kind of paper you have to use. And it warms my heart to hear that she is really enjoying your letters and that they're keeping her going 100%. And you guys are amazing. Released, then sent back to jail. Fitzsimmons did spend about 48 hours at home in between her 2 stints in jail. For at least one night, there was a glimpse of what life was like before. Fitzsimmons requested a certain meal, which her parents were happy to provide. We sat down and we had family dinner, Will Page said, adding that his 2 children, who were teenagers, and Fitzsimmons' father attended. We just had a regular dinner, and it was just a great night. They witnessed firsthand the difficulties Fitzsimmons had with completing testing using a Scram device, which tests for alcohol with the user blowing into a tube. Fitzsimmons almost passed out once and was left with severe pain after attempting to complete the tests. I will tell you, in case you don't know, in addition to being shot in the chest, having a collapsed lung, requiring the insertion of a chest tube, having bullet fragments that still remain in her chest cavity. I believe she has a lacerated liver, a couple of fractured ribs. And just those of you in the chat who have had a fractured rib knows how hard it is to breathe with a fractured rib and how long it takes for that to heal. And there's really not a lot you can do for a fractured rib. While probation did not consider the issues with the test a violation, a judge decided Fitzsimmons could not be out of jail unless she could complete the tests. Her family believed it would be a relatively straightforward day in court, so much so that Will Page didn't even attend. But instead of returning home, Fitzsimmons left the courtroom in handcuffs. She and her lawyers have fought her detention in every avenue available, first asking the judge to reconsider her order, then appealing to a single justice of the Supreme Judicial Court, and now the full bench. It's been disappointment after disappointment, the family said. Always in the back of your head, you're hopeful that somebody's going to see through what's going on and be like, this girl needs to go home and get the help that she needs, Lauren Page said, adding that her daughter isn't receiving any mental health treatment in jail. A spokesperson for the Hampton County Sheriff's Office told MassLive that every woman at the jail has access to a full range of medical and mental health services through our on-site, full-time medical and mental health departments. We take great pride in providing every individual with the care, treatment, and dignity they deserve, the spokesperson, Robert Rizzuto, said. After the birth of her son, Fitzsimmons was diagnosed with postpartum depression. In March, she was sectioned at Lawrence General Hospital after police responded to her home and found her distraught. The Pages declined to answer questions about what Fitzsimmons was like after giving birth, but they said treatment at Massachusetts General Hospital is hugely beneficial to her depression. Remember, the baby was born in February, so then she was diagnosed maybe not even a month later. Fitzsimmons was set to return to work as a police officer on July 4th after being cleared by a doctor. It was a job that she loved and one that represented the fulfillment of a childhood dream. It was just something that she had a thing for, a passion for, to help the community, to help the people in the community and be a part of that, Lauren Page said. It's difficult for either Will or Lauren Page to look forward with Fitzsimmons still in jail and so much uncertainty still ahead. Still, they remain hopeful that this latest step, appealing to the full Supreme Judicial Court, could bring Fitzsimmons home for the holidays. No trial date has been set for the 28-year-old, though it appears she could face a jury as soon as January. Well, remember the last hearing, the judge on the party line conference call said, oh, we can put this on the calendar next week. We can try this case next week. You want to try it next week? I can get you in next week. And Tim Bradle was like, yeah, Judge, we haven't even had discovery yet. It's just normal family stuff that we hope to get back to, Lauren Page said. That's the end of that article. Insane. Thunderhorse says some have asked if the baby has a guardian ad litem. No, not to my knowledge. One has not been appointed. I don't know if one would be appointed in Massachusetts at this stage. And so there has been no appearance as of yet by any guardian ad litem. Sorry, I just got to close some of these tabs because it's making me glitch. It's a great question, but the answer is no. Kippy Hippie says that's only if DCF is involved, right? And they are not. Carrie P says I didn't even think about this, Carrie. She needs to be home for the baby's first holidays. Wow. That's heartbreaking. Well, on that note, that was actually a good article, says KBD. A lot of you in the chat talking about the fact that you have had fractured ribs and how painful it is. Kylie says, it actually hurt me to listen to that first hearing when they did put her in jail because you can't not feel it after you know that pain. Heartbreaking. I Love Dogs 1970 says, Kelsey does not belong in jail, period. She belongs with her baby. Yeah. Blessed Mom from Texas says postpartum depression is no joke. I had it with my son. So glad I said something and got help. B. Michigan says, my beloved had a collapsed lung and a chest tube after a lung cancer biopsy procedure. I'm so sorry. There's no way he could have breathed deeply for any reason. I'm going to write to Kelsey. Thank you, Melanie. You guys are so sweet. Jenna Leah says, I know I say this every stream about her, but why is she in Chicopee? It's so far. I think they felt that they could better protect her in Chicopee because she used to be a corrections officer. And she's a police officer, and she's already had one issue over there because we had the police report and we went over the sheriff's report and we went over it. It is far. It's 2 hours each way that she has to sit in the back of a van to come to Essex Superior. So there's that. And the Canton Leaf Blower Society has decided to convene their meeting right outside my window with about 14 leaf blowers. So hopefully you can still hear me. Moving on. Chicopee is a hard place, says Irish Meemaw. Well, she was allowed to do Zoom, Ariana, for a couple of the hearings, but this one she wanted to be at. And, you know, let her be in the same room with her parents, right? At first, they didn't want to transport her the 2 hours each way. And so she was on Zoom for some of the hearings. And then some of them she couldn't call into because they didn't bring her there in time. But she absolutely has a right to be there, even if it is 2 hours each way. Little Cupcake says, do male cops with drinking problems and violent rhetoric get their kids taken away? Is that rhetorical? Thank you, Jay Rivet, for your $20 super chat. My brother died on the cement floor in the infirmary of the Dallas County Jail. No one helped him, but the inmates. Wow. I'm so sorry. He was very ill. This happened 18 hours after arrested. She's getting very little care. Free Kelsey. Thank you, Jay Rivet. I'm so sorry about your brother. Prayers up for Jay Rivet. That's a horrifying story. Kraken Studio says, meanwhile, Myles King, right, who's an accused murderer, is out on bail, right, because they kept him in jail for 3 years and didn't turn over basic discovery. And Kelsey is without her baby. Right. That's right. Lisa says, after watching courts in other states on YouTube, I kind of get why Massachusetts doesn't utilize the dermal scram devices. They seem to malfunction, often causing extra fees, violation reports, and hearings. That's interesting. Thank you. Jay Rivet says, we sued and won. Justice does happen. That's a great story. That's a great story. Myles violated Jenny, but I don't think they put him back in jail. Unless he violated again, because he did violate once, but it was a mistake because he moved and forgot to tell them. And then they straightened it out one day when we were watching a hearing, Jenny Cochran. So if he violated again, let me know, because I must have missed that. Hang on. Okay. Are you ready to move on to Patrick Rose Sr.? If you're in the chat, how many of you in the chat, if you don't know the story of retired, now incarcerated, former Boston police officer and president of the union, Patrick Rose Sr., if you do not know about the story, put a 1 in the chat, just so I can get an idea of how many people don't know about the story, because this saga has been going on for years and years and years. If you do know about it, you can put a 2 in the chat. I'll just give me some idea. Oh, wow, a lot of you guys don't know about. Oh, this is gonna break your heart. It's going to outrage you. Reminds me very, very much of the Catholic Church cases that I handled on behalf of many, many survivors / victims of clergy SA. When that scandal broke in 2002, that was a 15-year long fight. It reminds me of that a lot because there was some cover up, there was some hiding, there was some special treatment given to him as a Boston police officer. Right. So if you don't think that it's against children, his own stepchildren and others, if you don't think you can handle it, I'm giving you the out right now. I'm giving you the out. But this has been going on for a long time through the court system. He is now finally incarcerated because he finally pled guilty. But there is a federal lawsuit by the stepchildren against the Boston Police Department and other individual actors, DCF, higher ups who knew what was going on. And the allegations in the federal lawsuit are their civil rights were violated because of the actions of the Boston Police Department and DCF and others. And that not only that, but it enabled him to abuse them more and for a longer period of time because of such things as, vacating the restraining order and giving him his job back and dropping the IA investigation against him and interviewing his stepson while he was watching. Yeah, it's pretty vile. So if you can't handle, I completely understand, but you need to know about this case. So I think in order to do that, we're going to go back to his guilty plea, which happened in 2022. And then I'm going to take you to the decision, the reversal of the federal court decision by the federal appellate court in July, and then tell you where we stand today, because there's going to be argument in federal court on Monday. Because of course, the city of Boston is trying to dismiss the case or have the case dismissed based upon qualified immunity. Blanket trigger warning for everything that we're going to discuss about Patrick Rose Sr. And this may help you understand why the people of Massachusetts are so outraged and what they've been dealing with for decades, with maybe cops covering up for other cops and things like that. So come with me, if you will, back to April 25th of 2022, when the Boston Globe reported that former police union head Patrick Rose pleads guilty to abuse charges and sentenced to 13 years in prison. But the story starts all the way back in the 90s. That was a disgusting pop-up. Let me just, whatever that was, I can't unsee it. I need to go to reader view. Okay. God bless reader view. And thank you to the viewer who pointed that out to me, that I could get away from the pop-ups by installing something on my browser that allows me to go to reader view and avoid all the pop-ups. Deep breaths, and here we go. Former Boston Police Union head Patrick Rose pleads guilty to abuse charges, sentenced to 13 years in prison. This is April 25th of 2022. Patrick Rose Sr., not to be confused with Patrick Rose Jr., 67 years old, was arrested in 2020 and charged with 33 counts of SA of 6 children ranging in age from 7 to 16. In April of 2021, the Globe reported that Rose was allowed to keep his badge for 20 years after top police officials determined he more than likely SA'd a child in 1995. Okay. 1995, they were on notice. They interviewed the victim, who happened to be his stepson. But I don't want to give away too much because there's more to the story. Rose, who retired from the department in 2018, had maintained his innocence since his arrest. As part of a plea agreement, prosecutors dropped 5 counts of aggravated child rape, which would have required Rose to serve a mandatory minimum of 10 years in prison. Under the agreement, Rose was sentenced to 10 to 13 years in prison, but could be released on parole after serving less than a decade. This was an agreed upon case resolution to spare the victims from having to testify at trial, said Jim Borgasani, a spokesman for Suffolk District Attorney Kevin R. Hayden. The victims were fully on board with the plea agreement. So the original criminal charges were brought in Suffolk Superior Court, Massachusetts. Another survivor whose daughter was molested by Rose more than 2 decades later detailed the immense toll of Rose's crimes, including a cycle of substance abuse and self-harm. And I'm here to tell you from the, 50 or 60 victim/survivors that I represented, that is not uncommon. Substance abuse issues, self-harm issues, trust issues, inability to hold a job. Imagine you're a child and this happens to you, and that is your normal from there on out. Because when you're that young, you don't realize that it's wrong. Many people never disclose. Never did I expect to see that 1,000-mile stare in my own child's face, the survivor said. Countless PTSD breakdowns, nights spent in hospital rooms, knowing it's because you hurt us, haunts me every minute of every day. In a statement he read aloud just before he was sentenced, Rose expressed remorse for his crimes. I want to apologize for my despicable behavior. I am solely responsible for any acts that I perpetrated, he said. Do not allow your anger or hatred to destroy who you are. Do not allow yourselves to point a finger of blame to anyone but me. But in their statements, the survivors said Rose's refusal to admit his wrongdoing over the past 2 years had deepened their anguish. Your actions since you've been arrested have shown how selfish and heartless you truly are, a third survivor said, looking Rose directly in the eyes. This past 20 months could have been spent healing, but I can't sleep one night without seeing your face. You tried your hardest to discredit me from a very young age, the survivor said. Now I can finally let go of the shame and embarrassment I've carried with me my entire life, and we can finally see justice. In 1995, the police department filed a criminal complaint against Rose for sexual assault on a 12-year-old. Prosecutors said the child ultimately recanted under pressure from Rose, a common phenomenon for young survivors of abuse when faced with demands from their abuser. After prosecutors dropped the criminal charge, the police department proceeded with a separate administrative investigation, which concluded Rose most likely molested the child. Despite the determination Rose probably broke the law, police officials never recommended that he be fired, records showed. Okay, so they're on notice of this in 1995. And then they do nothing. And then 20 years later, he abuses another child because, as you know, these predators do not stop. They do not stop, which is why Aaron Spencer, in my opinion, should walk free. Then Police Commissioner Paul Evans and Internal Investigations Chief Anne Marie Darty released a joint statement in April 2021 defending their actions, saying that they were unable to discipline Rose because they did not have a witness or other evidence. We believed at the time, and we still believe, that everything that could be done by the Boston Police Department was done in this matter to hold Rose accountable, the statement read. Oh, wait till we read the papers. Wait till we read the papers. On Monday, Attorney General Maura Healey condemned Rose for his crimes and the failure of Boston police to hold him accountable. I was glad to see him plea. I was glad to see him convicted, and my heart goes out to the victims, the survivors, Healy said in an interview with WGBH Radio. It was incredibly disturbing to know that this person was allowed to continue to serve. Yeah. For more than 20 years. We don't know that we've gotten to the bottom of understanding how and why, but that can never happen again. Well, I'm going to tell you how and why when we read the civil lawsuit. Or at least we're going to read the decision from the federal appellate court. That's going to give you a whole lot more information, Governor. The fallout from Rose's case extended beyond his 6 survivors, reverberating at City Hall and beyond. Former Mayor Martin J. Walsh's administration refused to release public records related to the internal affairs investigation of Rose, even after a rebuke from the state supervisor of public records. Walsh's successor, former acting mayor Kim, Janey, reversed course and released a small portion of Rose's internal affairs file. Janey also pushed for a requirement that Boston police notify a City Hall oversight agency whenever one of its officers is accused of a crime. Swift action could have been taken in the 1990s to remove Rose from the department. Janey said at a news conference last summer, "It is shameful that it seems the actions taken were to protect their own rather than to protect children." On Monday, Judge Mary Ames offered consolation to the 6 survivors as she sentenced Rose, addressing them directly to applaud their bravery. "The strength you have demonstrated is unbelievable, and my wish for you all is peace," she said. "Frankly, Mr. Rose, they owe you nothing. You may beg their forgiveness, and perhaps they have forgiveness in their hearts, but they owe you nothing." And so that was in 2022. He was sentenced to 13 years. Will he do the whole 13? He was 67 when he was sentenced, which means he'd be entitled to be released if he serves his full 13 when he's 80. But wait, there's more. Because that took us all the way back to 2022. Of those 6 victims / survivors that he went to jail for, for abusing, 2 of them were his stepchildren, a boy and a girl. And they filed a lawsuit in federal court for a violation of their civil rights and many other causes of action. And that case has been pending for a while, and there was a motion to dismiss in the federal court that was granted by the federal court judge. It went up on appeal. And this is the appellate decision. I'm not going to read the whole entire thing to you because it's 32 pages. This decision was issued July 25th of 2025, but it's going to give you some more details into what happened back in the 90s. And so I'm going to read selected portions of it for you. Can you hear the leaf blowers, or is it just solely annoying me? I think it's just solely annoying me. So this is the United States Court of Appeals for the First Circuit. And it's John Doe, Jane Doe, and James Doe, because they are victims of SA. They are allowed to file without using their real names. Praise be. And here are all of the defendants. I'm going to just mute for a second. You thought it was your neighbors? Oh my God. Doesn't it make you crazy? It's like an ice pick in my head. Hold on. Here are the defendants. City of Boston, Paul Evans individually, Robert Dunford individually, Melbert Ahern individually, Amory Darty individually, LaDonna Hatton, Eileen Vanderwood, John McLean, Marie Donahue, Boston Police Patrolmen's Association, Thomas Nee, Patrick Rose Sr., Frances Rose, who is the wife of, or was, I'm not sure if they're still married, the wife of Patrick Rose, who is the biological mother of the two of the victims, Gail Sullivan, Cheryl Hilliard, Raymond Smith, Rudolph Adams, and the Boston Police Department, and Massachusetts Department of Children and Families, DCF Defendant Does 1 to 5 individually, BPD Defendant Does, and BPPA Defendant Does. This is an appeal from the U.S. District Court for the District of Massachusetts, and the judge who who dismissed portions of the case was Judge Dennis Saylor, Saylor, the fourth. Boyle Shaughnessy. Hold on a second. Why does that name sound familiar? Boyle Shaughnessy. Did they were they paid by the Commonwealth having to do with something about Karen Reed? I don't remember. And this decision came down July 25th of 2025. Opinion was drafted by Circuit Judge Rickelman. Trigger warning again. Marcy did consult them. Thank you, Nancy. Right? I thought I was being gaslit. Marcy consulted them. Didn't he pay them some money too? I forget how much, but I remember it from when we were going over all of the invoices from trial number 1 and 2. Was it Marcy's old firm? Yeah, was it Marcy's old? I don't remember now. That was the firm that Marcy worked for, said Dan. See, I do have a memory of some sort. Interesting. Okay. From 1990 to 1999, Patrick Rose Sr., a police officer with the Boston Police Department, essayed 2 children, John and Jane Doe. Rose ultimately pled guilty to 21 counts of child rape and essay in April of 2022. The Does, now adults, then sued Rose, the BPD, and a number of other defendants who played a role in the investigation and response to their essay allegations against Rose in the 1990s. Their primary claim was that the defendants had deprived them of their 14th Amendment right to bodily integrity by affirmatively enhancing the danger to John and Jane from Rose's abuse. The district court dismissed the case before any discovery. Oh, wow. Before any discovery. Okay. Just straight up on the pleadings. Looking at the 4 corners of the pleadings and dismissed it before any discovery. We've seen shenanigans like this before. It concluded that the defendants could not be held responsible under what is known as the state-created danger doctrine because the Does had not sufficiently alleged that the defendants' actions had enhanced Rose's abuse and caused them harm. It also dismissed the Does' remaining claims. We vacate the district court's decision as to the Does' 14th Amendment claims only. We conclude that the Does plausibly alleged that at least some of the defendants' actions enhanced the danger to them, meeting the first requirement of the state-created danger test. Thus, we remand for the district court to evaluate those actions under the test's remaining requirements. Background. So the first thing they do is talk about how that we take the complaint and their attachments and we have to construe everything in the light most favorable to the plaintiffs, which in this case are the victims. He was found guilty? The Irish fighter was found guilty in Suffolk court. Hello, Aiden Higgins from Dublin. Wow. I had doubts about that. I hadn't covered the whole entire case, but I did see a little tiny portion of his testimony, and I didn't know whether or not the jury was going to believe him. So I'm a little bit surprised by that. Did any of you follow that? I think it's Derek Crosby, who's an Irish firefighter. Yeah, the retrial, wow. All right. Well, there you go. We'll talk about that more another day. The first one was a mistrial. This was the second, right? The first one was a mistrial. His name was Terrence. What did I call him? Terrence Crosby. What did I call him? I don't know. Guilty. Okay. Sometimes when there's breaking news in the chat, I misconstrue it, so I don't really want to comment on it until I have a time to look into it myself. But okay. He's the guy who came over from Ireland to celebrate St. Patrick's Day. And the victim alleges that she went home with his roommate into the hotel and she had consensual relations with the roommate. Then she claims that she went to bed in the other bed in the room, I believe, and that she said she woke up and the other guy, the defendant, was graping her. Aiden Higgins says, Mel, I was on the same plane traveling to Boston for that event. That was St. Patty's Day 2024, right? We were going to get into that case, and then what just had happened was so much breaking stuff happened that we didn't. Okay. Sorry for the diversion, my friends. Initial allegations and criminal investigation. This is back to the Patrick Rose Sr. As we described earlier, this case arises from Rose's essay of two young children, John and Jane Doe, while Rose was employed as a BPD police officer. Both children lived with Rose, who was married to their mother, Frances. Rose essayed John Doe from approximately 1990 to 1997, when John was between 8 and 14 years old. And essayed Jane Doe from approximately 1990 to 1999, when Jane was between 5 and 14 years old. Rose also essayed 4 other children who were family members from at least 1990 to 2020. In case your math ain't mathin' today, that is a period of 30 years. He abused at least, well, for purposes of this document, 4 other children who were family members over a 30-year period, going all the way up to 2020. How many other victims do you think there are who are not family members? And who are they going to turn to? Boston PD? When they're still employing the predator and then he becomes president of the union? And here's where it starts. On November 8th on November 8th of 1995, the Massachusetts Department of Children and Families, DCF, received a report that Rose essayed John Doe, his stepson. 1995. That's the first report to DCF. DCF accepted the report for investigation that very same day. Later that week, the BPD began its own investigation. Lieutenant Marie Donahue and Sergeant Detective John McLean of the BPD's SA unit were assigned to the case. On November 10th, they interviewed John Doe in a police car in front of Rose's home while Rose and his wife Frances stood outside the home and watched. Are you horrified? Are you outraged yet? This little boy is sitting with Stabler and Benson in a patrol car. I'm using Stabler and Benson as an example. Telling them that the rapist, his stepfather, who's a Boston police officer, has been raping him for 5 years while the police officer stepfather and the kid's mother are watching. Do you think that there's anything wrong with that? Do you think, is that protocol? During the interview, John told the officers that Rose had SA'd him. The BPD officers then arrested Rose for indecent assault and battery on a child under 14 and prepared an internal BPD incident report regarding the abuse. I mean, so you bring a child. I'm still shooketh by this. An under 14-year-old child outside in a cop car, and you interview him while his abuser and mother are watching, and he can see them through the window. But at least they arrested him, right? Did they arrest him in front of the kid? That same day, Rose was served with a restraining order barring him from contacting John Jane, another child victim who was a family member, and a fourth minor, and then placed him on administrative duty by the BPD. Okay, so I'm going to just read between the lines here and say that John, little John, was brave enough to tell Stabler and Benson that not only was this monster abusing him and his sister, but also another child who was a family member and a fourth victim, because the restraining order piece of paper prevented Rose from having contact with any of those 4 children. And they put him on administrative leave. That's November 10th. On November 11th, the BPD confiscated Rose's weapons and license to carry a firearm. A few days later, 2 of John's minor friends confirmed to Stabler or Benson that Rose had forced John to touch him inappropriately multiple times. Now they've got confirmation from a witness. 2 witnesses, 2 children. After Rose's arrest from November 13th to November 16th, DCF employees conducted their interviews and investigation of John's SA allegations. Lieutenant Donahue, that's our Olivia Benson here, had previously instructed DCF not to visit the Rose home, quote, as the allegations pertain to a Boston police officer, end quote. Forget it. I can't even call her Olivia Benson anymore, because Olivia Benson would never do something like this. Okay. So DCF does their investigation for 3 days. They do their interviews. But one of the SVU cops tells DCF, don't go to the house. Don't visit the home, because he's a Boston police officer. Does that sound familiar? She indicated that she would visit the home instead to avoid any potential harm to the family, given that Rose was armed and could react in a hostile manner. I thought they took his guns away. That redhead is saying they didn't put him on admin leave. They put him on desk duty, right? Right. Contrary to investigative protocols, Lieutenant Donahue also instructed DCF not to interview John again. The DCF employees followed her directive and interviewed Jane, but not John, in front of Frances, the mother, who could have been an enabler. Just to break for a second from this case and talk about Aaron Spencer for a minute. The prior victim of Michael Fossler, who was the rapist of Aaron Spencer's daughter that he was trying to save when he pumped Michael Fossler full of lead, maybe, and left him on the side of the road to die while he was in the commission of another felony and kidnapping his daughter that he had raped and had like 43 felonies against him and was let out on $5,000 bail. The prior victim of Fossler did another interview with that same TikToker. She said, I can show it to you, so we're going to get into that another day. And that victim back from the 80s, because, you know, these guys just don't stop, said that Fossler's wife was involved too because she was in the room when it happened to her, at least. I haven't watched the whole entire interview yet. And so can you imagine DCF interviewing the daughter who they have confirmed was also SA'd by the stepdad in front of the mother? On November 16th, DCF concluded that evidence supported the allegation that Rose had SA'd John. It then referred the case to the district attorney. Remember, this is 1995. Several days later, Sergeant Detective McLean filed a criminal complaint in state court against Rose for indecent assault and battery on a child under 14. Rose was arraigned on that charge on December 1st, 1995. He was represented by an attorney working for the local police union, the Boston Patrolmen's Association, BPPA. At the arraignment, the court sentenced Rose to pretrial probation for 1 year until December 1, 1996, and ordered him to attend therapy directed by DCF. Rose did not comply with the state court order to attend therapy or with the restraining order issued against him, but none of the defendants took any action in response. Instead, the DCF consented to the withdrawal of the restraining order against Rose in January of 1996, just 2 months after it was entered. 2 months later, it's withdrawn. Just like it never happened. Like a piece of it. Just rip it up. It's a piece of paper. Just rip it up. No big whoop. So what happened? He continued to abuse the two kids that were his stepchildren for years. Similarly, in February of 1996, Anne-Marie Darty, the superintendent-in-chief of the BPD Office of Internal Investigations, and LaDonna Hatton, the BPD legal advisor, approved vacating the restraining order. This makes my heart hurt. Like my heart physically hurts. On May 7th of 1996, the Commonwealth of Massachusetts dismissed the indecent assault and battery criminal complaint against Rose 7 months before his pretrial probation period was scheduled to end. Just dropped it. The Commonwealth alleged that Rose had met the requirements of his pretrial probation and that the victims were no longer willing to cooperate with the prosecution. I'm just going to guess. But do you think maybe this monster threatened the children to recant. I don't know. Let's read on. 2, Boston Police Department internal investigation and reinstatement. Meanwhile, in December of 1995, Sergeant Detective Eileen Vanderwood of the BPD Internal Affairs Division, the IAD, prepared an internal complaint against Rose based on the criminal charge against him for indecent assault and battery on a child under 14. 5 months later, in April of 1996, the IAD ordered Rose to report for an interview. Sergeant Detective Vanderwood interviewed Rose in early June of 1996, but Rose asserted his Fifth Amendment privilege and refused to provide information about the allegations. The IAD sustained the complaint against Rose shortly after his interview, finding that he violated an internal BPD rule barring employees from committing any criminal act. Under that BPD rule, violators shall be subject to disciplinary action up to and including discharge from the department. Yet, none of the BPD officers investigated the allegations against Rose further, ordered or recommended disciplinary measures, or made a final disposition on the sustained complaint. I'm sorry, but didn't we read a little bit earlier in the document that there were 4 victims and that they even had 2 corroborating witnesses who were also children who may have also been abused, but we're not going to investigate it anymore. We're not even going to look into it. We're not going to recommend any disciplinary measures, even though he took the 5th, which, I don't know, may show consciousness of guilt in that type of an IAB situation, but, just throwing out my thoughts to you. And we know that it was true because he pled guilty in 2022, because that's the first thing we read. In May 1997, after Rose had been on administrative duty, right? He wasn't on administrative leave. He was on administrative duty, desk duty, at the BPD for over a year. His BPA attorney requested that he be reinstated to full duty and submitted affidavits from John, the stepson, and Frances, the wife, recanting John's allegations of SA against Rose. In October 1997, Rose's attorney also filed a grievance with the Office of Labor Relations for the city of Boston, claiming that the BPD had no just cause for placing Rose on administrative duty. The OLR denied the grievance. Even though the IAD sustained the SA complaint against Rose and the OLR found that the BPD appropriately placed Rose on administrative duty, BPD Commissioner Paul Evans reinstated Rose to full duty in May of 1998 without imposing any sanctions. Rose served as a police officer for the next 20 years until his retirement in 2018. Rose also was elected and served as the president of the BPPA from 2014 to 2018. That is the classic example of the fox guarding the hen house, in my opinion. I mean, he becomes the president of the BPPA. They elect him. I'm assuming it's an elected position. So I forget what. I was watching a stream last night. On that horrible case that's happening in Oklahoma, where the very high up in the Oklahoma State University football program, that guy's son has pled guilty, has pled no contest, which is essentially pleading guilty. He's 17 years old. Now he's 18, to raping and strangling 2 17-year-old girls at least. And one of them was 30 seconds from death. And he pled no contest, which means the judge is supposed to sentence him. And the sentence was supposed to be something like 100 and something years. But the judge was like, yeah, no, we're going to just let him do counseling for a year. And then, if he does that, we're just going to let it go. And I mean, predators protect predators, maybe people say. Horrific. Yes, Dr. Jen and Toxic, you were in the same chat with me last night, and the legislator was speaking. It was wild. And you had a different name though, I think, in that chat. I don't know why. I was confused. All right, hang on. He becomes the president. He was elected. Yeah, it says right here. He was elected and served as the president from 2014 to 2018, despite what they knew about him going all the way back to 1995. No big whoop. No biggie. After John's 1995 complaint, Rose continued to essay John, Jane, and the 4 other child victims, right, for the next 25 years. Number 3, renewed criminal complaint and prosecution. In 2020, when John was in his late 30s, he again reported to the BPD that Rose had SA'd him and 4 other victims when they were children. Massachusetts grand jury returned an indictment with 33 counts of SA charges against Rose. And in April of 2022, Rose pled guilty to 21 counts of child rape and SA and was sentenced to prison. So it took this child, who is now 33 years old, to march himself right back in there and say, what the fuck? Starter Villain says, you can't fix a child predator. There's no therapy or any treatment. I agree with you. Many of the priests, they used to send them to like pedo camp in Pennsylvania and say, oh, they're going away for rehabilitation. There's in my opinion, there's no rehabilitation. None. And when that jackass mayor of yours named the Quincy mayor made a statement very recently, within the last couple of weeks, when he was asked about the Catholic Church scandal, the Quincy mayor said something like, oh yeah, that wasn't pedophilia. That was just homosexuality. Sorry. I'm sorry. What? For those who don't understand, homosexuals do not target children. Okay? An adult who targets a child of the same gender is a pedophile. Yeah. He did say that. He did. He said the Catholic Church scandal was not about that. It wasn't about that. It was about homosexuality. He said it. We watched it together. We watched it. Yeah, his name's Koch or Koch. I don't know how he pronounces it. Koch. Yeah. Correct. Just be careful of the words that you use in the chat, please. Just, try and spell things creatively. And so that is why he finally pled guilty in 2022, because John had the fortitude and the tenacity and the strength to go back there after he was so horrifically brushed off as a child, and to bring all those other kids with him who are now adults to go through all of this again and relive all the trauma. Finally, that monster is in prison where he belongs, but it doesn't seem to me like 13 years is enough. Do you? Does it seem like that to you? Do you think 13 years is enough? I don't. Hugs to John for keeping up this fight for justice as Welcher's emotional support laptop. Nico says, I live in Quincy. Really disgusting that he said that. People were upset about it, but not enough, in my opinion. Yeah. I missed a grape in the document. Thanks, got milk for me. Yeah, they'll probably strike it anyway. John testified during Rose's 2022 sentencing hearing that Rose's essay escalated after the November. Start again, back to 1. John testified during Rose's 2022 sentencing hearing that Rose's essay escalated after November of 1995 because the city did nothing in response to John's report. So I remember because I took notes. John, the stepson, was essayed from 1990 to 1997. Had the city done something in 1995, they would have spared John 2 more full years of abuse. And they would have spared Jane 4 more years of abuse. And I don't have the exact dates on the 4 other children that were involved in those charges that he finally pled guilty to. But being that they continued for another 25 years and all of the unknown victims too, right? It's horrific. So in March of 2024, this is the procedural history. We're going to kind of buzz through this. John Doe, Jane Doe, and James Doe. So it's John Doe. So the stepchildren, James Doe is Jane's husband. Filed an amended complaint against Rose Francis, the city of Boston, individual BPD officers, the BPPA, the DCF defendants. Counts 1 through 10, alleged claims under 42 USC 1983. This is what they call a 1983 action against Rose Francis, the BPD and DCF defendants, and the city for violations of the Doe's substantive due process rights to bodily integrity. Counts 11 to 15 alleged claims under 42 USC 1985 against the same defendants, as well as the BPPA, the individual BPPA defendant, on the ground that the defendants conspired to deprive the Does of their civil rights. So a 1983 action is a violation of your civil rights, and a 1985 action is conspiracy to deprive a defendant of their civil rights or a person of their civil rights. The remaining 28 counts allege state law statutory claims and common law claims. Most of the defendants moved to dismiss the amended complaint under Rule 12. And what had happened was the district court dismissed the amended complaint in full. So the whole entire complaint, dismissed all causes of action. As relevant to this appeal, it's dismissed the 1983 claims against the Boston PD and the DCF defendants after rejecting the argument that these defendants violated the Doe's substantive due process rights by affirmatively enhancing the danger they faced from Rose. The court then dismissed the 1983 claims against the city based on its conclusion that the Does had not alleged any underlying constitutional violation by any city employee, and thus they could not meet the test for municipal liability under Monell versus the Department of Social Services of the City of New York. The Does timely appealed, and then we get into the standard of review. And the bottom line here is that the court finds, and we'll just get to the pertinent facts. Here's the 3 arguments on appeal. Number 1, the plaintiffs contend that the district court should not have dismissed their 14th Amendment claims against the Boston PD and DCF defendants because they plausibly alleged that these defendants are liable under the state created danger doctrine. Think about that before we get into it. Did they create a danger by allowing the predator to go back home and live with the family that he was abusing? By letting him off, vacating the restraining order, not forcing him to do his counseling or whatever. Terrific. Relatedly, they point out that the district court should not have dismissed all of their claims against the DCF defendants sua sponte without giving that does an opportunity to be heard. So the court just dismissed all the DCF claims without allowing the plaintiffs to even argue it on their own. Second, they argue that their 14th Amendment claims against the city should have survived because they were injured by the city's custom of mishandling citizen complaints against police officers. Third, they claim that the district court erred in dismissing their 1985 claims on the basis that they are not members of a protected class. We address each argument in turn. The first one is the 1983 claim. The Due Process Clause of the 14th Amendment provides that no state shall deprive any person of life, liberty, or property without due process of law. To establish a substantive due process claim, the does must show a deprivation of a protected interest in life, liberty, or property, and that the deprivation of this protected right was caused by governmental conduct. Here, the parties do not dispute that Rose deprived the does of their liberty, interest, and bodily autonomy when he essayed them, but they disagree on whether governmental conduct caused this harm, and thus whether the defendants may be held liable for Rose's SA. Footnote 5 says, the does brought their 14th Amendment claims under 42 U.S.C. 1983. To state a claim under 1983, a plaintiff must allege 1, the violation of a right protected by the Constitution or laws of the United States, and 2, that the perpetrator of the violation was acting under color of law. The parties disagree only about whether the does have alleged a constitutional violation. None of the defendants, other than Francis, dispute that they acted under color of law. And as we noted earlier, the does do not challenge the district court's dismissal of their 14th Amendment claims against either Francis or Rose. Yeah, Wild Aussie Woman says this crappy court system is by design to further traumatize survivors over and over again. It is what it is, and it needs to end. In particular, the parties dispute whether the defendants can be held liable for Rose's SA under the state-created danger doctrine. Footnote 6 says, tell us what the danger doctrine is. Wait. No. The district court concluded that none of the does allegations were sufficient to state a valid claim under this doctrine against any defendant. But on appeal, the does contend that the complaint is replete with allegations of affirmative acts by the individual defendants that could form the basis of a successful state-created danger claim. We focus our analysis on 4 of the acts alleged by the does against the BPD defendants because, as we explain below, we agree that those acts are affirmative and thus could potentially provide the basis for a state-created danger claim. So, in order to show a state-created danger claim, you have to show an affirmative act. It can't just be that they failed to act. Like maybe they failed to act in Harmony Montgomery, but that's a whole another issue because I think they did settle that case for a lot of money because they affirmatively gave Harmony Montgomery to Adam Montgomery in New Hampshire. I'm not sure because I haven't read those papers, but that's an example. And here are the acts, the affirmative acts that this appellate court is saying the defendants did, which absolutely provide the basis for a state-created danger claim. Number 1, Sergeant Detective McLean and Stabler and Benson's decision to interview John in front of Rose, his abuser, Number 2, Donahue's instruction to DCF not to visit Rose's home or re-interview John. Number 3, Superintendent-in-Chief Darty and legal advisor Hatton's approval of vacating the restraining order against Rose. And 4, Commissioner Evans' decision to reinstate Rose to full duty. We disagree with the district court that the Doe's 14th Amendment claims against the BPD defendants fail at the initial prongs of the state-created danger test. We also conclude that the court should not have dismissed the 1983 claims against the DCF defendants without permitting the Does to address those claims in particular. Thus, we remand for the district court to reevaluate the 14th Amendment claims against the BPD and DCF defendants. So this appellate court, this federal appellate court for the first, I think it's the First Circuit, revived the case, sent it back to the lower federal court for continued discovery. And they go on to say, with regard to state created danger, when the state creates or enhances the danger to an individual from that private violence, then a due process claim may be available, citing another case. Then it goes on to say what you need to show and that they agree the plaintiffs did show, even though there was no discovery, but because these allegations were within the 4 corners of their amended complaint, it's good enough. Thank you very much, TB's non-consensual privacy advocate, for gifting 5 Attorney Melanie Little memberships. You're amazing. Welcome to the 5 new viewers and 5 new members. And thank you very much. MMG Enrichment says, baby blue is your color. Thanks for your coverage. Thank you. Thank you for being interested in this topic. Toasty Bun says, just when you think it can't get any more corrupt and disgusting, hold my beer. Yeah. Hold my White Claw, as the case may be. Thank you, Toasty Buns, for your 10. Jojo says, there's special places in the depths of hell for these kind of monsters. Not even Satan would do that. Disgusting. Thanks, Jojo. And Jojo throws down another 20 and says, thank you, Melanie, for highlighting these types of cases because not a lot of people are talking about it over here. Forever my favorite lawyer on YouTube. Oh, thank you, Jojo. And Courtney from Canada says, as a survivor of childhood SA, thank you for shining a light. My abuser was sentenced to 3 weeks. No. I was age 4 through 9. This is Canadian justice. I'm so sorry, Courtney. Thanks, Beth, for becoming a member. And Joe just said, that's it. I'm done with humanity. I'm looking to permanently rehome myself to another planet. Well, don't go to Canada after what Courtney just told us. Thanks for your super chat. And thanks, Christine Ann Hamilton, for becoming a member. And Nicole is here. And Nicole Ray. And she says, hello. Hello. Cardi B voice. Hello. Did you get my email on the AML hat? Yes, I showed it during another stream. I live in Sedona and there's a lot of hat embroiders. I can make a sample for you. XOXO. Oh, thank you, Nicole. Unless you sent me another one. I mean, I remember you sent me the one with the mock-ups, but I've been so busy that I haven't had a chance to even go back and see if I can have them make that on Spreadshop, but I will. Thanks for reminding me. Also, just to remind you, there's a sale in the merch shop today. I think it's like 20% off $70 or more. The merch shop link is below in the show notes. So if anybody has an interest in getting any merch, I put some Christmas ornaments in there. So there's Christmas ornaments now. Just saying. Paula says, there is never enough time for those who harm or fail to protect children. I think those are among the most heinous of crimes. And a lot of people don't believe in the death penalty at all, but there are circumstances in which I think that it could be completely appropriate. Oh, thank you, Xenia. I'll take a look at that. But let me just get through this first. Because you know what happens. I think I have adult ADHD. I think I'm like, oh, this topic, that topic, this time. And I'm trying so hard. I'm really trying to focus on one topic at a time because that's what happens. We get off on all of these side conversations and then I never finish the first topic. And I'm working on it, you guys. I'm working on it. but let me pull it up, or otherwise I forget. I'm like, okay, we'll talk about that later. And then I forget to talk about it with you. Well, I don't know. You said that Ted Daniel has new papers on new court documents regarding Proctor's phone. I'm looking, where did he put it? Because if it's, I don't see anything in his feed. If you want to send it to me, send me a link. You could send me a link. But I mean, the last thing that he said was something about cannabis 7 hours ago, and then something on the 23rd, and then something on the 22nd. So I don't know what you're talking about. I don't know about any new court papers regarding Proctor's phone. Okay. Oh, look, a squirrel. Yeah, exactly. And then TV's non-consensual privacy advocate gifted 5 members, and Thunder Horse became a new member. And Courtney from Canada says, just to add, there was 4 of us that came forward, and he had to serve 1 week per year spread out over 3 years to allow him to continue working. Oh, that's horrific. Courtney, that's horrific. So he only had to serve 1 year in jail per year over a 3-year period, and there were at least 4 victims. That's horrific. I'm so sorry that happened to you. It was not your fault. You did nothing to deserve that. And so the court goes through much more analysis, but the good part of this decision is that it got sent back to federal court for the case to be able to continue. However, there is now pending another motion to dismiss by the defendants. And the Boston Globe had a great article about that. And so we will read the article, because sometimes it gives me a break from having to explain it, because sometimes the article can explain it. This is actually an opinion piece. This was published yesterday, October 23rd of 2025. And it goes like this. In the Patrick Rose case, city officials dodge accountability. I think I should be like Emily Baker and just not even look at the chat at all during streams, and then I won't get so distracted and angry and throw tantrums about the mean things that people say to me, and then they clip it and they put it all over the internet, and it's embarrassing for them because they're such losers that they have nothing better to do with their time than clip my F word tantrums and post them all over the internet. When it comes to the long, sad, and shameful case involving convicted child molester Patrick Rose, the more things change in city leadership, the more things stay the same. Dodging accountability is still the goal. After pleading guilty in 2022 to molesting 6 children over several decades, Rose, a former Boston police officer and president of the Patrolmen's Union, is finally in prison. But how he was allowed to keep his badge for more than 20 years after top police officials determined it was likely that he essayed a child is still a mystery, and the administration of Mayor Michelle Wu is aiming to keep it that way. City lawyers are seeking to dismiss a complaint filed in 2023 by 2 victims of Rose against the city of Boston, former police commissioner Paul Evans and other defendants whose actions they allege deprived them of their constitutional rights by enhancing the danger from Rose, their abuser. In a brief filed last month, city lawyers asserted the defense of qualified immunity. So that's in a different brief. A legal doctrine that protects government officials, including police officers, from civil liability unless it can be shown their actions violated a clearly established constitutional right. A hearing on the motion is scheduled for October 27th, which is Monday. But it's federal court, so it won't be televised. So if you're interested, you can go down to federal court and watch it. Watch the arguments on Monday, if you're so inclined. The plaintiffs, now adults, are identified in court documents as children who lived with Rose, who is married to their mother. In an interview, Janine, I'm going to butcher her last name, Kutylo, a lawyer who represents them, said the lawsuit, which seeks unspecified damages, is about more than money. It's about addressing a long record of institutional complicity. Members of the Boston Police Department used their badges and authority to protect a monster who was essaying children. The attorney told me their protection allowed the abuse to continue for years. Shielding that misconduct by asserting qualified immunity is morally wrong, especially from an administration that advocates for transparency and criminal justice reform. A spokesperson for Wu declined comment on pending litigation, but said Wu stands by her record of increased transparency and accountability for Boston police. A federal district court judge dismissed the case in 2024, but last July, a federal appeals court judge sent it back, saying the plaintiffs should get a chance to argue that actions taken by city and state officials helped Rose continue his abuse. As reported at the time by Universal Hub, the appeals court judge focused on 3 allegations. The officers who were investigating Rose in 1995 interviewed one plaintiff who was then a boy in a police car in front of the Rose household as both Rose and his wife watched. That one officer involved in the investigation told state officials to not re-interview the boy, and that a Boston PD official approved the vacating of a restraining order against Rose. In their brief, city lawyers say that only officials directly involved in those alleged actions should be subject to legal action, that there's no evidence that the officers' actions caused more harm. Well, the kids were abused for how many more years, and how many other kids were abused? So, would you argue that that is actual harm? I would. And that they are protected by the doctrine of qualified immunity. The city also argues that the officers' actions did not shock the conscience, which is one element of a state-created danger test that paves the way for legal accountability for public officials. The city has every right to try to get the case dismissed, but doing so puts Wu in a weird spot. After Rose was convicted, she said his story would lead to reform. And that was 3 years ago in 2022. And to some extent, it has. A collective bargaining agreement signed with Boston PPA, the BPPA, Boston Police Patrolmen's Association, in 2023, designates a list of offenses, including rape, that are not eligible for arbitration as a pathway to overturn discipline or termination. Wu also did more than previous mayors to disclose information about the Rose matter. When Rose's conduct first came under scrutiny, Tom Menino was mayor. After a Globe investigative report in 2021, questions about the case resurfaced during the tenure of former Mayor Marty Walsh. After Walsh left office, acting Mayor Kim Janey released 13 pages of the Rose file. After she won the election, Wu released a redacted version of the full Rose personnel file in 2022, saying that horrible injustices took place in Boston. But Wu also noted that while the file exposed systemic failures, it did not reveal who allowed Rose to continue as an active member of the BPD. Deposing key players under oath could shed light on that. I guess there's been no depositions yet. They don't want it to get that far. The depositions will open the floodgates. Let's see, because it just got sent back to the federal court in what are we saying? June, July. It's only been a couple of months. They made another motion. I guess there hasn't been much discovery. My clients want the public to know the truth and for all the people responsible for this to be held accountable. Their attorney said, the sexual abuser is behind bars, and that is some justice, but the people who allowed him to commit these crimes and protected him are still out there. This suit can help expose these people and what they did to ensure that justice is complete and this never happens again. It should not take a lawsuit to get such accountability. If this case is dismissed, chances are that it will never be achieved unless Wu finds another way to make it happen. That is an opinion piece by Joan Venocci, a Globe columnist. Say you. Qualified immunity. That's what they want to hide behind this time. Okay. Thanks. This is so Ted Daniel did actually post something at 21:23. Oh, you know what? It must have been a reply to something. Hold on. That's why I didn't pull it up. Only 7 minutes ago. He says, we have a couple of more details from a new filing about Michael Proctor's phone. I'll post my story as soon as it's done. Yeah, because there's also some more information about that whole, you know, how Corey Hopkins uncovered the email from an FBI guy named Kelleher to BPD Commissioner Michael Cox about Kelly Dever. And then there's a calendar invite that says there was like a calendar invite that 2 hours later, he called her down for a meeting after getting that email. So I don't know. Maybe somebody is saying that maybe Commissioner Cox might have been mistaken when he was asked by reporters about Kelly Dever. Maybe he was mistaken. But before we move on to another topic, let's just let me see if I have any comments here about Patrick Rose and what's going on there. Do you think that the city should be able to hide behind qualified immunity? I don't know. There it is. KBD says it. The states made a big deal about abolishing qualified immunity for police officers, but they really didn't. Right. Maria says, I don't know who could possibly be ringing my doorbell. Unless it's like a DoorDash for my kid. Hang on a second. Hold, please. Nobody rings the doorbell. I got a flower delivery. Well, it's a good thing I spoke to him through the ring bell camera because I could tell him just leave them. I think they're for me. He said, hi, Melanie. I was like, okay. All right. This sickens me, says Maria DeAndrea. Massachusetts is a joke. Oh, you heard him? Did I not mute myself? I thought I muted myself. No, flowers, not flower. Flowers. Because I got no flowers back there. Then they all died. My sunflowers died. Somebody's knocking at my door. Somebody's ringing the bell. Woohoo. Woohoo. Catherine Smith says sale of houses should be put in trust for the baby. They could also make arrangement for her to see the baby and not wait for court, but it sounds like he won't entertain that idea. Father rarely wants full custody. We'll see what happens. We'll see what happens. He didn't even ask for it to be put in trust or an escrow. I mean, that would have been like a more reasonable ask, in my opinion. However, there's been no determination as to custody. And apparently the father, you're talking about Kelsey Fitzsimmons, I'm assuming, Catherine. Thank you for your 10. The father, there's been no determination as to custody yet. I've never seen this, I've never seen this requested in any family court proceeding before. I don't know if this is something that's commonly done in Massachusetts, but she's got to pay for her attorneys too. And she's the one who owned the house. And why should he get his digits on it in my opinion, when full custody has not even been decided yet and won't be. So maybe he should focus on making more money. That's all I'm going to say about that. Hold on. He just wants the proceeds of the house. I forget what the mortgage is and I forget what the sale price is, but I want to say it's like close to maybe a $200,000 profit that she's going to make, but she needs to pay her lawyers, right? Yeah, something's going on. Something's going on here. There's a little more to the story, I think, Catherine. I think you know what I'm talking about. Thank you for your I found the video on the hat. What color do you want? What are you talking about? Oh, you mean when I talked about the hat? What colors do I mean? I like the gold lettering on the black hat. A lot of people liked it. I thought that would be a nice one. So just email me. We'll correspond by email. Okay, sweetie? Thank you. Because I got too many things in my brain to think about it. But I like that black with the gold lettering. It was really nice. You're the best. Thanks, Nicole. Stop qualified immunity, says Professor Tarfeather. Rhonda says he should get nothing from the House. Before I pivot to Golden Bachelor, because I have to talk to you about that. And EKG says, hey, ladies, there's another one to immediately swipe left on if he shows up on your app. I don't even know. You're too young for me. But since we're talking about it, is anybody else watching The Golden Bachelor? Or am I the only person on the planet watching The Golden Bachelor? No, one of you did because one of you emailed me about it. And you said, I'm rooting for Cindy. Who are you rooting for? And I said, I'm rooting for Cindy too. I was rooting for Cindy since the first night when she walked out of the limo. They did the hometown dates. Now there's only 2 left. I can't show you the flowers because I didn't go get them. They're outside the front door. I told him you should leave them because sometimes they just put a slip on your door and they're like, we tried to deliver flowers, but call back and we'll bring them back. And I was like, no, just leave them there. It was you. It was you. Cal says me. I want Cindy too. I liked Cindy from the beginning. Shady Norfolk County DA's office says it's her money. Yeah, she's got a lot of medical costs too, right? Do you think her insurance? First of all, tell me if the North Andover PD officers have good insurance. Usually, like if you're a government employee or a municipal employee, they have really, really good insurance. But there's got to be a lot of stuff that's not covered. Maybe she maxed out. She's got tons of medical expenses. Okay, good. We'll get to the Golden Bachelor in a minute. We'll pivot to that. Just remind me. Oh, look, it's some shiny. Audrey Hepburn's right in front of me. Breakfast at Tiffany's. I love her so much. Okay. Dreamland says, in mid-1990s, McMinnville, Tennessee, middle school coach was charged with 49 counts involving children. He was found guilty on 48 and got 11 months, 29 days, 0 prison time. Repulsive. Cali Lily says, they weren't married. Why does he think he deserves anything from the house proceeds? Bizarre. Oh, because he thinks that he's going to get full custody of that baby Caden. They've said his name. So I'm now doxing him. He thinks that he's convinced that he's going to get full custody of baby Caden and that he should just get future child support, like right now, paid in advance until that little boy is 18 or 21 or however long it goes. And he should just get it up front. He should just get it now. That's what he thinks. He should just get the money now. It's wild behavior, Kylie. I know. It's wild. She paid for all the remote. She paid for everything, right? And now she's forced to sell her house to pay for her attorneys and her medical expenses. So if you choose, please donate to Kelsey's fund. It's down below in the show notes. Every dollar helps. You know that good legal representation is expensive. But hopefully they're going to agree on some things right now, because that sounded hopeful at the beginning. If you guys are behind at the beginning of the stream, it sounded hopeful, like they were coming to some sort of stipulation. The parties were agreeing on some stuff, and hopefully Kelsey's going to get to see her baby soon. Hopefully the full panel is going to hear that appeal. Hopefully they're going to do it soon, and hopefully they're going to see the light in what we see, and that the court did not take into consideration any reasonable accommodations because of Kelsey's disability, and it's horrific. You think he's going to pick Cindy, little cupcake? All right, let's talk about it. Let's talk about it. Golden Bachelor. We're pivoting now. Mitchell says, Peg the firefighter has too much energy for me. Too much energy to say for me or for Mel? Oh, the guy's name is Mel. That's right. I thought you meant me. I'm like, what? Okay, yeah. So they're down to, if you haven't been watching, they did 3 hometown dates. Cindy, who's the very beautiful brunette, who's been divorced for like 7 years. And then Peg, who's the firefighter and bomb technician, right? From, let's see, Cindy is from Austin, right? Peg is from, where's Peg from? And I think the third was from Denver. And the third woman, what's her name? Remind me. Was it Joan or something? She had never been married. And I kind of felt bad for her, because I was like, oh man, if he doesn't give her a rose, it's not going to go well. She's never been married. And Peg is from Las Vegas. Thank you very much, Mitchell. So she's a firefighter and bomb technician. And she brought him into the firehouse to see the guys. Mitchell's so into it now. And where was Deb? Her name was Deb, right? She had never been married, and she's in her mid 60s or early 60s. And she was a fitness instructor of some sort. And where was she from? Debbie's never been married. And she was the one to go home. She didn't get a rose. So now are we doing fantasy suites next? Fantasy suites next week, and the women tell all. And it's down to Peg and Cindy. But Peg is from Texas. Thank you. I thought wasn't also wait, where was Cindy from? Wasn't Cindy from Austin too? And then the other one was also from Texas. That's not how we do it in Massachusetts, Mr. Jackson. We're just going to keep talking about the Golden Bachelor until we get the breaking news on Proctor. How does that sound? Peg definitely has too much energy from Mel. Cindy would be the better choice, but I think Mel isn't ready for a relationship. I know. I think that, nothing will happen between Loophole Lawyer and me at all. I thought that was funny. He did a video with me cursing, because I never curse. But he kind of did me dirty on that video, because instead of pulling like from my real stream where I really said those things, he pulled from like 10th generation Twitter video. And so it was like not good quality. Like he should have just pulled it from my real stream. Did you guys see the Loophole Lawyer video with me cursing? And I forget what the topic was besides me cursing, but it was something else. I thought that doesn't bother me at all. I thought it was amusing. Wait, yeah, I don't know. Peg was in California? Yeah, I don't think, Mel, that was the thing with the hometown dates, when questioned by the family, like the daughters of Cindy, and even like Cindy's daughters, he couldn't say, they were like, are you in love with our mom? And he's like, I really don't know. Like, I don't know what's going to happen in the next days and months. Yeah. Peg's from Las Vegas. I'm trying to figure out where Deb was. Cause I know Cindy was somebody was from Denver. Maybe Deb was from Denver and Cindy's from Austin. And Peg's Las Vegas. Peg is very real, and she's got a lot of energy. And I feel like, I don't know, is it possible that he won't pick anyone at the end? Commonwealth's motion for protective order regarding information derived from the review of extraction from Trooper Proctor's phone. That may have been something that I already have in the Walsh case. Yeah, I found the Loophole Lawyer video to be all in good fun. Like, that doesn't offend me at all. I thought it was funny. But I really don't think that Mel is like related. I mean, I don't think he's ready for a relationship, because he's not really saying how he feels about any of them. Usually the guy is like, he says, I love you to all of them. But that Nicole, that one who wanted to be like an influencer, Good thing I can't wait to see what she says on the Women Tell All one. Tell me what you think. You like Cindy's polished life, yeah. But I just feel like, I don't know. I feel like Peg could handle it better. Because I feel like Peg is gonna land on her feet. She's great. She's like resilient. If he doesn't pick her, she's gonna be like, all right, whatever. And she'll just move on to the next. And so I feel like Peg will be better. I feel like Cindy will be heartbroken, but I feel like Peg can totally survive it if he says no. And I don't know. I feel like maybe he will pick Cindy, but she was my choice from like day one when she walked out of the. Yeah, Nicole was a skank, says Norfolk County Sound. It's a shame. A lot of you guys are watching it. A lot of you guys are watching it. Cindy is super sweet. And she's such a great mom. And her daughters are beautiful. It looks like she really raised them right. And Peg looks very cool too. But I just feel like Peg's going to be fine if Mel doesn't pick her. Right? And Rochelle says, yes. I was thinking the same thing. The Golden Bachelor may hold out for a younger woman. It's what he's used to. I don't know. After him being on this show, I don't know that it's going to play well for him in his future dating endeavors. But because remember, he was on a podcast and he said he didn't want to date anybody over 60. And so the producers, in like the best case of revenge ever, only picked contestants that were in their 60s. How funny was that? Golden Bachelor brought to you by Cialis. That would be a great collab, actually. Right? No shame. Hold on. CPU Mod 1 says, again, can't wait for the Rainmaker tonight. I'm not caught up. I think I saw it fly by that you were, it's going to be like episode 11 tonight. I think I'm only on like episode 6 or 7, but if you haven't been watching it, it's on Peacock. It's the Rainmaker. It's based on the John Grisham novel. And it's really good. It's really good. I like it a lot. Thanks to Tom CPU's sister for recommending it to me, because it reminds me about like being a young lawyer and like all of the hope and promise from like taking the bar and how you think you're going to go out there and change the world. And I really like it. If anybody else is watching this, except for the two of us. Just another snark in the tank says, I turned 60 tomorrow. Happy birthday. Does that put me in the running or out of the running? No, you're in the running. Maybe for the next Golden Bachelor, or maybe it's going to be the Golden Bachelorette. Hello, Music to My Soul. I'm doing pretty well today. How are you doing after your medical appointment? I'm glad you got to catch some of the end of it. Michael L says, The Rainmaker is an excellent TV show. I know there's not a lot of things that are capturing my attention right now on television. I feel like I need to ride out the Golden Bachelor because I kind of told you guys to watch it. So now I feel like I'm watching it on replay. I'm loving the morning show, which I've always loved. And if you have not watched Dax Shepard's interview on YouTube of Jennifer Aniston, it's really good. I haven't finished it yet. I think I have like another hour, but it's like 2.5 hours long. Thank you, Michael. I'm glad you're watching it too. High Potential is another great show. Is that new? Because I think there was an old show called High Potential that I watched a while ago. Robin said, this group of ladies wasn't nearly as fun as last year's. Oh, the finale was last Friday on Rainmaker? Oh, okay, then I got to catch up. Don't tell me. No spoilers, please. Christine's like, he's too freaking old to ask for someone younger than their 60s. Yeah, and he's also like, he's a retired football player. He thinks he's all that, but I don't know. And he's like all like, namaste, but I don't really find him to be so namaste. Do you? Or Zen? Like he's got all the bracelets on and stuff, but like, I feel like he's a little more high strung than he's trying to let us believe. Second year of High Potential, cute show. Wait, hang on. Let me go to IMDb so I can tell you if that's the one that I watched the first time. There was another show. It was named something like that, but it was like about a bunch of like bank robbers that came together. And it was really good. And I forget the name of it. So, I mean, and I think they were going to make a second season. Let me just see if this is it. Why are you glitching? IMDb Pro. Come on. Oh no, this is the one with this is the one with, I like her a lot. She's also in Hacks, right? Caitlin Olsen. She's in Hacks, which is a show that I love. I forget the show that I'm thinking of where there was like a bunch of like bank robbers and they like pulled off this really cool heist. And I think it was only one season. It was really good. The single mom that collaborates with the police department. Okay. I like her. I like Caitlin Olsen. She plays Jean Smart's daughter in Hacks, and she's really good. Joe Law says about Mel, the Golden Bachelor, he's a problem. He will not stay with whoever he picks. When identified herself in explicit terms as a pick me prediction, she'll be picked, and then shortly after filming, unpicked. Dun, dun, dun. Kathy RRN is highly recommending Buried Defense Diaries new podcast. Excellent, excellent, excellent. Shout out to Defense Diaries. Everyone should go listen to it. It's audio only, right? Oh, the Murdoch is good, right? Are you watching Murdoch, Aiden Higgins from Ireland? I caught up on that one. Did the new episode come out yet? It was good. I do not watch Elsbeth. Do you, Mitchell? Do you watch it? That's funny. Michael says, what's funny is that all the actors on The Rainmaker are British in real life. They have British accents, as does the actor who plays Alec Murdoch, who I think is doing a great job. We'll have a couple more details from a new filing about Michael Proctor's phone. Yes, we saw that earlier, Anne. Thanks. We're waiting to see what it's about. What, if anything, it's about. I did not watch Sirens. Should I? Oh, sweetie, no. um, Everyone loves High Potential. I'm getting a lot of good recommendations here in the chat. A lot of good recommendations. People are loving the Murdoch series too. I mean, Patricia Arquette is good in everything she does, right? She can't go wrong. I mean, although I can't ever unsee her playing Gypsy Rose Blanchard's mother. And so it's hard to see her in any other role for me. Louise Young says Mel is really boring, not me. Notice when you see Mel in the chat today, it's regarding the Golden Bachelor named Mel. His name is Mel. He's a former football player, and he is really boring. Like, think about it. If you were on a date with Mel, what would you have to talk about? Football. I mean, I love Hacks too. Hacks is one of the best written shows ever. And what I love so much about it, the actor that plays the agent. He's the agent of both Jean Smart characters and Hannah Einbinder's characters, right? He's both of their agents. He is actually the writer of the show, him and his wife. It's a husband-wife team that writes the show. And the writing on Hacks is so excellent. And it's so funny. And oh my God, the girl that plays the assistant is so hilarious. Her name is escaping me right now. I think it's Megan. She's so funny. The Murdoch series is on Hulu. It is on Hulu. Hacks is amazing, hilarious. The writing is first rate. Everyone's writing all the shows down. We're giving you some, because sometimes you got to get away from YouTube. Look, I watch YouTube a lot too, but there's times when I'm just like, I can't do it. I can't do it anymore. I can't watch the same topics over and over and over again. And the same drama over and over and over again. I'm getting tired. She is so funny. Meg Stalter, that's her name, Meg Stalter. If you guys don't follow her on Instagram, you should, because she's so funny. Oh my God, she did a funny thing about, I think it was about Tilly Norwood. Remember Tilly? Yes, Hannah Einbinder is Lorraine Newman's daughter, the original SNL cast member, Lorraine Newman. Her daughter is Hannah Einbinder, who plays the young writer in Hacks. And they've won 1 million Emmys. And Jean Smart deserves every single one of them. Every single one of them. She's amazing. She's an icon. Goliath. That is one of my favorite shows. Goliath is one of my favorite shows of all time. And I wasn't really ever into Billy Bob Thornton until I watched that show. And then I was like, oh, I get it. I get it now, Billy Bob Thornton. He's a disgraced alcoholic lawyer who gets kicked out of his law firm, and then he gets his revenge. Oh my God. It is so good. If you haven't watched Goliath, go watch it. I forget what it's on. I did watch Damages, and that is one of my all-time favorite shows of all time. Damages with Glenn Close. Also an amazing, amazing, amazing show. And Christine says, yes, that made me love Billy Bob Thornton too. Yes. And then it takes place in Santa Monica, Goliath. And he lives in like this seedy motel, which he also has his office in there. And it's next to a bar in Santa Monica called Shay J. And if you know, you know. So when I was in California one time, I'm like, oh my God, I had to go to Shay J just to check it out and take a picture there because, that's what I'm like not a grief tourist, but like where TV shows are filmed, like American Horror Stories, like that house. My daughter and I when we were in LA, we had to go find it, and we found it, and we took a picture there too. The new Proctor story is out. Okay, so let me see. Hold on. I promised you. So I tried to always abide by my promises. So hang on. Let's see if somebody sent it to me. Okay, here it is. Ted Daniels' new article on Boston 25, hot off the presses, or the press. Not the whole presses, just the press.
Thousands of new items were found on his personal cell phone.
Here we go.
Is learning more about what's on ex-state trooper Michael Proctor's cell phone. Investigative reporter Ted Daniel is joining us now live. Ted, you obtained an interesting court filing late this afternoon.
Yeah, Rachel, we told you earlier this week that Proctor dropped his appeal to get his job back with state police after thousands of new items were found on his personal cell phone, including text chats, audio files, pictures, and video. We're getting a little more information about that now. Some details are contained in a new court filing from the Norfolk County District Attorney's Office. The filing says Proctor's phone contains sensitive images of intimate body parts of people not on the text chain. Screenshots of Facebook posts, phone numbers, and emails of all the people Proctor communicated with, and the name of a sexual assault victim. The Norfolk DA's office.
Images. I'm sorry if I just blew your ears out. Images of intimate body parts. MassLive, if you're watching, it looks like a filing in the Myles King case. And it looks like it is, hold on. Looks like Myles King, right? Yeah. Okay. Let's just take that back a notch because
DA's and the name.
Images of intimate body parts, like depicts.
And emails of all the people Proctor communicated with, and the name of a sexual Facebook.
Hold on. We're going back. Hold on.
Sensitive details are contained in a new court filing from the Norfolk County District Attorney's Office. The filing says Proctor's phone contains sensitive images of intimate body parts of people not on the text chain. Screenshots of Facebook posts, phone numbers, and emails of all the people Proctor communicated with, and the name of a sexual assault victim. The Norfolk DA's office is asking a judge to restrict the public release of those items and a lot of other sensitive data from Proctor's phone. The DA's office continues to review an extraction of that phone. A judge has ordered prosecutors to share any data that is considered favorable to defendants in several cases Proctor investigated. The filing does not say if the intimate body part images are connected to a case Proctor work or images shared among friends. The DA's office says it will allow a judge to privately determine what items are relevant to other criminal cases before sharing them with defense attorneys. For 25 Investigates, I'm Ted Daniel.
Oh, oh, wow. So
Every member of your family.
it is far worse. I mean, no, it's not really, because we totally predicted this. I totally predicted that there was going to be nudes. And I was like half joking. I was half joking when I said that. Na, 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 hey, goodbye. So it looks like it's a new court filing, docket number 174 in the Myles King case. I don't know that it's been scanned yet. Ted Daniel had his source give him a copy of it. So it is the Commonwealth's motion for protective order regarding information derived from a review of extraction of a former Massachusetts State Police trooper's personal phone. It is docket number 174 in the Myles King case. And as soon as it lands in my inbox, we will actually read the actual physical filing. But until we can get it, let's look at the article just published a few moments ago. Judge asked to shield highly sensitive data from former trooper's phone. A new court filing reveals that the personal cell phone of former Massachusetts State Police Trooper Michael Proctor contains thousands of sensitive items, including intimate images. Okay, so just to rewind a bit, we knew that when they did the total extraction, we just found out that there are hundreds of thousands of items on the phone, even though Proctor's attorney said there's not going to be anything on there. He auto deletes every 30 days. You're really not going to have much, but here you go. In August of 2025, they found hundreds of thousands of items, but now a new court filing says that out of those hundreds of thousands of items, thousands of them are sensitive, including intimate images. Okay. Oh, if you're behind, you might want to get to real time right about now. This comes days after Proctor dropped his appeal to regain his job with the MSP, citing new disclosures shared with him. Proctor was fired in March for conduct that was revealed in Karen Reed's first trial. The Norfolk County DA's office filed a motion for protective order in Superior Court on Friday, asking a judge to strictly limit the dissemination of text, chats, audio files, pictures, and video obtained from an extraction of Proctor's personal phone. According to the motion, the data being reviewed as part of discovery in cases Proctor investigated, including the Myles King case. Well, if they're behind, why don't you just tell them in the chat? Just tell the people in the chat, say, if you're behind, please come to real time because you're missing the breaking news about Proctor. And then they'll know. Because it seems like they're watching the chat, but they're just behind in the video. And so it's so much better to watch it in real time. Okay. The Norfolk County DA's office filed a motion for protective order in Superior Court on Friday, that's today, asking a judge to strictly limit the dissemination of text, chats, audio files, pictures, and video obtained from an extraction of Proctor's personal phone. According to the motion, the data being reviewed as part of discovery in cases Proctor investigated, including the Myles King case, spans many years. The Norfolk District Attorney's Office is concerned about the highly sensitive nature of the information, including images of intimate body parts of people not participating in the text chain, screenshots of Facebook posts, full phone numbers and our personal email addresses of the people Proctor communicated with, and the name of a sexual assault victim. Screenshots of Facebook posts. Weren't there allegations at some point during this mishigas that the wife of Michael Proctor, Lizzie Proctor, was calling the employers of people who posted nasty things about her on Facebook? Am I imagining that, or did that really happen? Could that have been it? for things that, people were saying mean about Proctor, and he would screenshot them and send them to Lizzie and tell her, and she would call their employer and try and get them fired. But it really could be anything. It really could be anything. The most shocking part, if you want to call it that, is the intimate body part pictures of people not participating in the text chain. I have surmised, hypothesized, and spitballed with you that when Michael Proctor told his buddies at the MSP, including his superiors, that he was just no nudes yet when he was looking through Karen's phone in July of 2022 or whenever that was, that it wasn't the first time, maybe, in my opinion, that they had done that, and that maybe it was a custom and practice and habit. They didn't find any, or he didn't find any that we know of, but I don't know. Could he have found them in Brian Walsh's phone? Could he have found them in Harry Turk's phone? Could he have found them in Myles King's phone and other defendants? And would it become relevant in their criminal cases? Because it could, depending on what they find, show bias on the part of Michael Proctor, which could cause a jury to let a defendant go or to find them not guilty because of the extreme bias of Michael Proctor. And a Norfolk County jury is probably going to be fully familiar of what went on with the 2 trials of Karen Reed. And they probably already know about Proctor, unless they're living under a rock. And Christy says it looks like it was a regular thing. And this could be the reason that the police union backed away from Michael Proctor, calling him an embarrassment, an embarrassing chapter in the Massachusetts State Police history. They pulled their support for him. They pulled his lawyer from him. And that is why, because a week ago today, last Friday, because it always happens on a Friday, right? He's going to need a flight to Vietnam. It says crushing capacity, AKA 18-wheeler. A week ago today is when that total extraction was given to Proctor's attorneys. And then the next day, on the Saturday, is when Proctor signed the discontinuance of his appeal to try and get his job back. And that is also when the union pulled the plug on him. They took his lawyer away, and he withdrew his appeal. Because there were supposed to be 3 days of hearings this week, Tuesday, Wednesday, Thursday, for Proctor's continued appeal to get his job back. However, we learned about it on Monday. And now we learn that the Norfolk County DA's office is concerned about the highly sensitive nature of thousands of items found in Proctor's total phone extraction, including images of intimate body parts of people not participating in the text chain, screenshots of Facebook posts, full phone numbers, and our personal email addresses of the people Proctor communicated with, and the name of an SA victim. A judge had previously ordered prosecutors, Krupp, to share any data from the phone that contains materials favorable to the defendants in several criminal cases Proctor investigated. The Norfolk DA's office says it will allow a judge to privately determine what items are relevant to other criminal cases before sharing them with defense attorneys. There's Ted Daniel with the breaking news. Now, there seems to be some confusion among the Twidiots who seem to go out there and say they didn't find anything incriminating about Jennifer McCabe because they would have had it for the first trial, and they didn't have it, so it doesn't exist. And I'm going to explain to you why that's an incorrect argument. The Jennifer McCabe text messages that surfaced prior to trial number 1 were contained within the federal TUI dump, which happened in February of 2024. Therefore, what was contained in that dump only contained data, and it seems like only text messages, by the way. It seems like there was no photographs, emails, audio files, up to and maybe including February of 2024, What has now been downloaded is Proctor's entire phone extraction going all the way up to August of 2025. And so everything between February of 2024 to August of 2025 will be contained therein. And so therefore, if Jennifer McCabe or any of those other people inside 34 Fairview had communications with Michael Proctor after February of 2024, they will be contained in this total phone extraction. Thank you so much for allowing me to explain that to you in very basic language. But Jennifer McCabe didn't even know him until this investigation. So there's nothing. They're not going to find anything. Okay. Okay. But the phone extraction was done in August of 2025. And so therefore, everything prior thereto and contained therein, including intimate part photographs, emails, audio files, video files, not just text messages, Megan, I can see you, are going to be contained there. So, you know, get out the popcorn. And Mama before Denise says, how many people are lawyering up right now? How many people had a direct line to Proctor? And how many group text messages was Proctor involved in? Was he involved in groups? Because all those will be on there too. Might not have been such a great thing to have a direct line to Proctor, I would submit to you. Maybe the access that you thought you had to Proctor could come back and bite you in the ass. I don't know. I don't know why people still think that, you know, auto delete is a thing. The tea is piping hot. Proctor is the antithesis of proper. Sorry. Sorry. But like, who else was in communication, do you think, with him? Telling him what to do, bossing him around. Oh, the resignations. His phone is telling everything, maybe. To the point where Rosemary, the Commonwealth made the motion, right? The Commonwealth made the motion. The DA's office made a motion for protective order today in the Myles King case. Because they found such salacious stuff that they want the judge to even have a copy. And maybe, Judge, you can go through it and you can look at all the depicts. Because it says of intimate body parts. It doesn't just say of naked people. It doesn't say naked people. It says intimate body parts. Was anybody sending Michael Proctor like titty pics to do like something for? I mean, could this be what finally leads to divorce court? I don't know. I mean, Zimmy says, I bet this was a team effort. Emily says, haha, Judge Krupp was begging to be on this case. That's the punishment you get. And then it was Proctor's attorneys who opened up the can of worms by filing a motion for clarification. It's Proctor's own attorneys did that. And then Judge Doolin had limited it on Myles King from the date of the indictment to the date of the arrest. And Judge Krupp took over and he's like, yeah, no, I'm not limiting it to any dates. All dates are available to everyone. I mean, that is so crazy. Landman with Billy Bob Thornton is great too. Just a Girl from the 6. Yes, I love that one too. I do love Landman. I'm waiting anxiously for season 2. And also, John Hamm is in it. And Ali Larder is also amazing in that show. Highly recommend if you guys haven't seen it. Christine says, Melanie, instead of Stand By Your Man, we need to add the song Divorce to the playlist. I don't know that song. Who sings it? Not Fade Away. Kai says, SA victims, can they get him on HIPAA violation? Oh, Kai, I think that's the least of his worries. That's the least of his worries. No, I don't think it would be a HIPAA violation. It would be a violation of talking about, you know, a case, an investigation to people that are not, other law enforcement investigators. But I would think a HIPAA violation, he would wish for a HIPAA violation at this point. On top, thank you for your super sticker. It's going down. It's going down. Proctor is done. Proctor is done for. Look at this user changed their name to Proctor is done for and just says it's going down. I mean, Karma Train is just chugging along, says Space Dudette. Guy's like, yeah, very true. LOL. He wishes it was a HIPAA violation. And Eve says journalists should be outside his house ready to ask him questions like they used to do. Yeah, but now they're afraid, I think, of getting charged with witness intimidation. So, there's that. Wow, right. Christina says, no wonder Cosgrove doesn't want to turn this over to Turtleboy. I mean, Aiden had a win this week in that Michael Morrissey himself signed off on the charges of the 2024 case involving Lindsay Gattani. Those charges have been dropped in case you missed that nugget. Dee says, wonder what Proctor's going to find under the tree for Christmas this year. Kylie says, the ease with which all of these people lie tells you everything you need to know. Sarah McBride. Billy McBride, that's the character naming Goliath. His name's Billy McBride. Sarah McBride says Fridays have not been friendly to Proctor. No, they sure haven't. Oh yeah, that's the Halloween party is right tonight, right? Is anybody in the chat going to the Halloween party tonight? Turtleboy's Halloween party in Malden. Welcher's emotional support laptops. So many of them are just as bad as Proctor, but slightly smarter and not caught yet. Myles King is charged with murder. Murder. Deb just says, finally, HIPAA is only for medical people, right? But I'm saying that he wishes that was his problem. Wouldn't have done anything differently, right, Proctor? Says Megan. Oh man, does anybody have? Oh, can somebody email me a link to his 2020 video? Does anybody have it like at the ready? If you have it at the ready, email it to me because we should watch it. I think it'd be a great thing to watch right now. Go get your popcorn. Thanks, Megan. Yeah, he wouldn't have done anything differently when he was asked. Christine says, do you think he found pictures while going through Walsh's phone when he claimed his wife was having an affair? Perhaps Walsh found pictures that his wife sent to her supposed lover that Walsh had. Yes, so many possibilities, except it seems that, I mean, I had been surmising that for a long time that, maybe he found nudes on a Walsh, but what if there's like a file somewhere with like all the nudes that they ever found in any defendant's phone or anybody's phone that they ever looked through? Like the ramifications of this and the ripple effects of this are huge, opening up the floodgates of civil litigation and maybe even criminal appeals all over the place. Thank you, Christine, for your 10. And Antas says, bad. I mean, Diane says, rumor is Chip's been bunking at his sister's. Oh, Chippy Bear. No, I haven't watched Righteous Gemstones, but a couple of my kids really like that show a lot. I have not. Do you like it, Sheila? And yeah, Rosemary deserves a high five. She's so smart, says Deanne. Yep. I mean, yeah, the interviews of Lizzie and Courtney didn't age well either. Truth. Let me see if I can find it real quick. Let me see if I can find it real quick. Oh, I got it. I have to suffer through a commercial first, but do you think we should watch it again? Yeah, let's watch it again because he's the gift that keeps on giving. And really, quite frankly, maybe he should have thought twice before he did this interview, eh? This is Matt Gutman. I said the same thing. I don't doubt that they are going to drop all the Turtleboy's cases either. They have to because they have to admit that Lindsay is a witness in the 2023 case because that is the grand jury subpoena that they served her with. So they can't admit that it was a false grand jury subpoena. And so if they served her with a subpoena to come into court for December 27th to testify for the 2023 case, she has to be a witness in that case. And so therefore, because she's suing Michael Morrissey's office and because she's suing Cosgrove and everybody, they have to recuse themselves or find another county to prosecute. There's no two ways about it. All right, this is Matt Gutman doing the interview of Proctor, and this was all the way back. When was this? June 18th of 2025. Was this the same day that Karen Reed was acquitted? That's right. Do you remember this? The same day that Karen Reed was acquitted, they aired Michael Proctor's interview, right? To try and take away, Matt Gutless, to try and, somebody said, to try and take away, you know, the excitement of her acquittal. Wow. All right. We're going to watch it. But I'm just going to make it a little bit smaller like this. Okay. There we go. This is when he tried to like redeem himself. And it was the same day as her acquittal. Oh, I remember this well. Wait, how do I full screen it? Hold on. Okay, here we go.
At what point did you develop such strong negative feelings about Karen Reed that you would say things like, hopefully she kills herself, or calling her the C word?
Those feelings developed as the case went on.
Can you see how people might think, he was
I-
caught in this instance
Yeah.
speaking about a suspect in this way. Maybe it's happened in other cases as well.
Oh, I'm going to have to keep stopping this for fair use purposes. So you need to understand that is the law. When you're using some fair use content, you have to commentate and make it different. So he developed some feelings, and also the music sucks, but we're going to suffer through. Oh, it just started over. Okay.
Such strong negative feelings about Karen Reed that you would say things like, hopefully she kills herself, or calling her the C word.
Those feelings developed as the case went on.
Yeah.
I mean, can you see how people might think, he was caught in this instance speaking about a suspect in this way. Maybe it's happened in other cases as well.
I 100% understand why people would think that. But when you have, you know, a fellow police officer around my age, 2 kids of his own, it generates an emotion. And I express that.
Well, if you're that emotional, maybe you should not be doing police work. Maybe you shouldn't be doing police work. You're so full of shiitake mushrooms. This is Proctor's 2020 interview from June 18th of 2025. They played it the same night in 2020 that Karen Reed was acquitted. This is what they decided to go with. Michael Proctor's apology tour. Here we go.
Those emotions in a negative way, which I shouldn't have. I shouldn't even, been texting my friends anything.
Oh,
They are what they are. They don't define me as a person. They're regrettable.
At what point did you develop such strong negative feelings about Karen Reed?
Oh, that's just one little tiny loop. Oh, that's just one little tiny loop. All right, well, that doesn't do me any good. I was looking for the full interview, maybe on YouTube, but, that didn't age well. I'm sure you can find the whole video on 2020 on demand somewhere from June 18th of 2025. Oh, thank you, Emily. Thank you, Emily C. Oops. Let's take a look at the interview from the interview of Proctor's wife and sister that Emily C just sent me. I think that's what this is, Emily, right? It's okay, my friends. I will suffer through the commercial for you.
What do you want to say to anyone who believes the narrative,
that's him again,
the
too.
defense's narrative that you are corrupt, that you framed Karen Reed?
I laugh because it's such a ridiculous accusation. There's not one piece of evidence or fact to support that.
We laughing
because it did
too.
not happen. I would never do something like that.
Did you crack the taillight to make it look a certain way?
Absolutely not.
Did you frame Karen Reed?
Absolutely not.
His little laugh is telling us everything. His little laugh was telling us everything. Wasn't it? Absolutely not. Oh boy. And Matt, is it still funny? Yeah, it's still funny. It's still funny to me. Who's laughing now? Wow. There's not one piece of evidence. There are hundreds of thousands, and thousands of them are sensitive, according to the Commonwealth. According to the Commonwealth. And we have the filing. We have it now. Thank you to Karen, who's the first one in with it. 30, 29, 31. Okay. Thank you. We got the actual filing, not just the Ted Daniels article. Thank you very much to Karen who sent this to me. All right. Here we go. Look at it. We always pivot, right? We always pivot. Always here with the breaking news. And nothing gets by us because of you guys. That's why. Let me just pull up the papers so that we can read them. I got to get them in some sort of order. Hold on. Talk amongst yourselves for a minute. All right. Are you ready for it? Are you ready for it? All right. It's 4 pages long. That's fun. I mean, isn't this fun? It's a lot more fun than talking about Patrick Rose, that monster. I'll tell you that much. But, it's Friday, so we knew this was going to happen. All right, here we go. And this is what Ted Daniel just broke a few moments ago. Let's see. And what we have here is in the Myles King case. Now, this was filed, remember, by the Commonwealth. So this is the Commonwealth's. Let me just see if I can make this bigger. Hold on. Much more better. Much more better. Okay. And it is allowed. It is signed here, allowed. Looks like Peter Krupp signed it today, October 24th of 2025. This is docket number 174 in the Myles King case. Commonwealth's motion for protective order regarding information derived from review of extraction of a former Massachusetts State Police trooper's personal phone. Tell your friends what we're reading. We're here. Tell your friends. Oh, I'll link my earrings when I finish. Just remind me, Rob, again. You know what? Let me just star that comment. They may be linked to a prior stream, but I'll link them to this stream also. $65 you can get them too for your wife. Okay. The Commonwealth moves pursuant to Massachusetts Rule 14 that the dissemination of materials from an extraction of former state police trooper Michael Proctor's personal cell phone be restricted. As grounds, on June 17th of 2025, this court, Judge Doolin, in specific cases, allowed in part defense motions for discovery of former Massachusetts State Police trooper Michael Proctor's personal cell phone. The order included that the Commonwealth produce communications from the dates of the charged offenses to the dates that indictment issued and produce any other data from Proctor's personal cell phone that constitutes investigative materials or is favorable to the defense within the meaning of Rule 14. Footnote 1, here's all the cases to which they refer is Commonwealth versus Myles King, Commonwealth versus Sean Johnson, Commonwealth versus Bianca Ciancio, and Commonwealth versus Giovanni de los Santos, but also I believe it's also Brian Walsh. The court further ordered that the Commonwealth may move for appropriate protective orders for the court's review prior to producing items and information that defense counsel shall not show or provide. Hold on, I got to get the next piece of paper. But I got to close that one. It's like a whole thing. Hang on. When you get early access to these documents, sometimes, it's JPEG. We got to do what we got to do. And we get what you get and we don't get upset. And here it is. The communication produced pursuant to this order to anyone else except that defense counsel may show but not give them to the defendants in this case. Upon filing of a motion and amended motion for clarification by the former Troopers Counsel on August 13th, this court, Peter B. Krupp, judge, clarified that the obligation to produce any other data that constitutes investigative materials or is favorable to the defense is not limited to a particular date range, and that the former trooper had a legitimate interest in protecting attorney-client or spousal communications. The court issued further orders about delivery and extraction of the phone, the opportunity for the former trooper's counsel to submit a privilege log, and a timeline for the Commonwealth to produce discoverable materials. Footnote 2, which says, Commonwealth v. King, Commonwealth v. Johnson, Commonwealth v. Chancho, and Commonwealth v. De Los Santos. Under Massachusetts law, all items and information favorable to the defendant within the possession, custody, or control of the prosecutor, prosecuting office, or prosecution team must be disclosed. See generally Brady versus Maryland, Giglio versus the United States, and Graham versus the DA for the Hampton District. Review of the personal cell phone is ongoing. At this time, pursuant to Rule 14, the Commonwealth is producing text chats, audio files, and video files, which span many years. One text chat contains highly sensitive information, including images of intimate body parts of people not participating in the chat. Okay, let's use our context clues, shall we? So one text chat, it's one chat. Now remember, Proctor had a habit of talking to his grade school buddies in chats, group messages that went on for years. And I remember, I think it was during, he didn't testify in the first trial, in the second trial. So at the first trial, he testified that there was something like 35,000 messages between him and his buddies, like his grade school buddies, right? So while it says there's only one text chain, it could have been a text chain that was going on for years, right? Because he never really deleted anything. Oops. And it says including images. So more than one image in the one text chain that could have been going on for years. Could it be every time they found a nude, they threw it into this group text message? I don't know. Just, using context clues. Because it says images of intimate body parts of people. So more than one person not participating in the chat. Right. Sarah says, he said no nudes yet, AKA he normally sends them. Screenshots of Facebook posts by non-participants. Images of non-participants. Oh, photos of people. Oh. Full phone numbers and or personal email addresses of the text chain participants. Well, that's commonly redacted. We'll let you do that. No worries. And the name of a sexual assault victim. Oh, it also says people, not women. Yep. Oh boy, we got to get to page 3. Hold on. Page 3, coming in hot. Under Massachusetts Rule 14, upon a sufficient showing, the judge may at any time order that the discovery or inspection be denied, restricted, or deferred, or make such other order as is appropriate. The judge may alter the time requirements of Rules 14, 14.1, and 14.2. The judge may, for cause shown, grant discovery to a defendant on the condition that the material to be discovered be available only to counsel for the defendant. This provision does not alter the allocation of the burden of proof with regard to the matter at issue, including privilege. The issuance of a protective order is the inherent authority of the issuing court, and protective orders serve to shield litigants and third parties from unwarranted disclosures and, as a practical matter, to facilitate the discovery necessary for a trial. Non-parties have a privacy interest in not having their images, their complete cell phone numbers, or email numbers publicly displayed. Names of SA victims in court records or police reports may not be disseminated except with the consent of a justice of such court where the complaint or indictment is or would be prosecuted and are otherwise withheld from public inspection. The DA's office is like, please, Judge Krupp, help, help, help. It says right here, reports of SA shall not be public reports. Well, that's interesting because Tully apparently doesn't know that general law because isn't he the one who released Lindsay Gattani's alleged grape report without any redactions? Do you think he did it on purpose as a nudge or a bump? Oop. Further, non-participants who appear within the produced materials may have a security interest in not having their personal identifying information released to protect against harassment. Commonwealth v. Holliday, while Commonwealth bears the burden of demonstrating risk of safety, it need not demonstrate a specific or actual threat where danger to witness safety is inherent in the situation. Further, where such information was provided upon court order in specific cases and dissemination was subject to restrictions as a condition of its release, this court should order similar restrictions prior to the production of the materials in this case. Accordingly, there is good cause to limit dissemination to one copy, that further copying be prohibited, that the materials be shown but not provided to the defendant. And this is in Myles King. Remember, this has nothing to do with Aiden Kearney right now. And that the materials are not otherwise disseminated outside the criminal case. There's no protective order yet. Has anybody made a FOIA request? Anybody in the chat make a FOIA request yet? The materials will be provided in an electronic format with text chains, including embedded audio files. Oh boy. Oh boy. Can you imagine if people were leaving like voice notes? You know, because we've learned in other cases that people like Kate Peter were leaving voice notes. Oh, they've got them. Where the text chains include the name of an SA victim, the Commonwealth requests that it be allowed to omit the electronic version of the messages that include an SA victim's name from the electronic production so as to redact the SA victim's name and provide as a PDF. Review of the extraction is ongoing. There may be additional materials that the Commonwealth will provide under Rule 14. To streamline future discovery, the Commonwealth requests, as set forth in the appended proposed protective order, that where the Commonwealth believes that there is good cause, future production of materials from extraction be redacted or limited to the defendant's counsel, and dissemination of such materials be prohibited outside of this criminal proceeding, limited without prejudice to a motion to modify the protective order by either party on good cause, stated XOXO. Rosemary Scapiccio. It looks like they've agreed to it. She's agreed to it. And William J. O'Driscoll, who's the ADA, who signed off on this today, October 24th, 2025. And then this says, we're limited to the defendant's counsel. And then it's written in there. I'm not sure what that says. I can't read that. Her associates, an investigator, maybe. I think that's what it says. Footnote 3 says, upon request, the Norfolk DA's office will make the materials believed to be discoverable to the court for in-camera review. Citing CPCS versus the Attorney General, where Commonwealth is in possession of information that may otherwise be subject to discovery, it must file a request for protective order and present information in camera review. Wow. Wow. Oh, it says experts. Thank you, Tom Gully, who can read chicken scratch for a living. It says her associates, experts, and investigator. Wow. Wow. There you go. Associates, experts, and investigators. You guys are better at reading the chicken scratch than I. I mean, what do you think? I'll tell you what you think. Let's see. Debbie Marie says, late today, have to replay, but wanted you to know that the show with Samantha B and the I Don't Belong Here was great. Oh, thank you. I had a lot of fun over there on that at her house. She'll have to come to my house next time. Boxer Mom said, love Wednesday night show with Samantha. Thank you guys. Thank you. Laura said, hi, Melanie. I don't say much in the chat, but I wanted to tell you, I think you're great. And you're definitely my favorite law tuber. Oh, thank you, Laura. I love that. And I love you. And the Lion, the Witch, and the Audacity of this bish says, happy Friday, Melanie. Thanks for hanging out with us today. I mean, come on. How do we not? How could we not? How could we not? We know something's going to happen. That's why I waited for the afternoon to do the show. Because I knew it was going to happen. I knew it was all going to happen today. Who's the C word now, Proctor, doughboy? Oh boy, huh? Says on top. Thank you. KLM says, didn't we read that information from the phones is being shared to defense and police agencies or something like that? Oh, yes, we did. We did. But I don't think he needs the court's permission to do that. That was in the previous papers. And now, because the first motion that we read in which that sentence was contained said, Judge, we need more time. That was a more time motion. That was like, please, we need more time. You set a deadline of, I think today, Friday the 24th. But we need more time because there's hundreds of thousands of messages. We think we're going to be able to get to the texts and everything, but there's so many photos and so many emails that we need more time for that stuff. So we anticipate being able to turn over some or most of the stuff by the 24th, but we need more time for the rest. And also we have an ongoing obligation, as we know, because we are prosecutors, that there is stuff that we have found that we will be turning over. They said, we'll be turning over to independent law enforcement agencies. That was a week ago. We covered that last Friday night, Fun Day Friday. And then today was the deadline. And so they filed this, in which they have absolutely said that there are pictures of intimate parts of people in one of the text chains, multiple. And we know how long Chippy Bear Proctor had his text threads going for years. It could be his buddies. It could be his employee, his former colleagues, right? And you're exactly right, KLM. That's exactly what they said. And so we can just use our imagination on that. But independent law enforcement agencies, well, it could mean FBI, could mean internal affairs, could mean other district attorneys or other police agencies. Yeah, it's his personal phone, but because he used it to do business, it's discoverable. Christine says Proctor is thinking, damn, if I were born 30 years earlier, I could have went to Vietnam for free. Harvey, can I catch a flight with you? No offense to my sons, to my vets. To vets. My son is one. Thank you. Thank you, son, for his service, for us. Thank you, C3PO, she 3PO, for your $10 super sticker. That was super nice of you. Thank you so much. Mass Witch Hunt 2025. How many thousands of messages are related to Aiden? I'm sure he complained about that Turtleboy guy to his friends. Yeah. Well, I think Aiden has said that he had a special nickname for him. He hasn't told us what it was, but they did have a special nickname, or Proctor did, I think. And Aiden has said, I mean, it feels like it was a long time ago now that Aiden has said that the messages that have been released to Aiden and his team will blow your mind. Like, if you thought the ones to Karen Reed were bad, these are a million times worse. That's what he has said. And thank you, TLR, for your Cash App that says, thank you for the lives helping me make it through a day of work. I appreciate you. And thank you, Kelly, for buying a matcha latte so very much. And also, it says someone sent you a matcha latte. It's anonymous, but whoever that is says, really enjoy your show. Thank you so very much. And Kelly said, another fabulous Friday. Yes, I'm sure they complained about him quite a lot because, in fact, there was something that actually, there were some messages in there in which that have already come out. Do something. Do something. And I think there was a message that came out in which Proctor said, can't we just arrest him already? Why can't we just arrest him? Right? That already came out maybe in the mega motion. I don't know. So many papers, so little time, so many cases conflating in my head, but I know you guys have it straight, and you will absolutely straighten me out if I say something wrong. On top, sending all the super stickers today. You're a sweetheart. Kay Wills is here. She's a realtor, and she says, if this information reveals who killed John O'Keefe, will it be able to be used to indict? Well, do you think they would reopen the investigation? I mean, sounds like who knows what could be in there, okay? But the answer to your question is yes. Could it show evidence of crimes? Could it show evidence of conspiracy? Could it show confessions from people? Probably not. Could it? Could it show a picture of the taillight totally intact with just a crack in it? Could it have like some, okay, like, because now I remember, like, I'm thinking of this, right? Wasn't there, walk me through this. There was testimony, or maybe on cross-examination during trial number 1, Proctor was asked, I think it was Proctor who was asked, did anyone ever send you a picture of the taillight? Right? Thanks, H-Nix, but now and then. It's a long time ago, going all the way back to 2024. Did anyone ever send you a picture of the taillight so you knew that you were looking for? And he was like, no. But there was other people who were questioned about that too. Like, remind me. Tully? Tully. It was right, Sarah? It was Tully. The CERT team guy asked Tully for a picture. That's what it was. Thank you. Thank you. See, look, 3 Clerk Monty. I knew somebody would come in here, and that's exactly what I'm thinking. The CERT team guy, his name was it Connor Keefe? Asked Tully to send him a picture, and he was like, yeah, no, I don't have one. Right? Sarah watched it today. And KBD said the same thing. So what if there was one? I don't know. What if there was one? Tully wanted pictures for the CERT team. What if they're there? They asked the CERT guy, right? Was it Connor Keefe who said that he was the guy that was there when they started finding the pieces? And then also, who was the guy who was like the head of the CERT team? And he said, yeah, there was a couple people there. I didn't really know who they were. A couple of like randos. couple of randos on the scene. He's like, I assumed they were law enforcement, but I don't really know. I don't really know. Yeah, Bob says, I'm worried that the nudes is going to be an excuse to hide what we all deserve to see. Well, just portions of it. Just portions of it. I'm waiting to see what happens with Corey Hopkins' lawsuit about the unsealing of the sidebars, because we should have a decision on that soon, because we absolutely 100% the public is entitled to see what's in those sidebars, and they're fighting her a little bit. But the public has a right to see that. That is part of the trial record. That is part of the court record, and the public has a right to see it because trials are public. Tully told him not to come yet, says Kathy. Kevin O'Hara. Kevin O'Hara? Thank you, Sarah. Kevin O'Hara was the head, right? He was the head MF in charge of the CERT team. And he was like, he really didn't have a command post, or his command post was inside his patrol car. But, you know, anybody put eyes on Proctor? Adam Lally's resignation. That's just a username. Don't start any rumors. Bo, did you change your name back? Says there's going to be a lot in those sidebars. Oh, if you're back on that stream, you need to go watch the stream. I mean, if you're back, if you're behind in the video, and you said, I'm back at the place where you're talking about the high school or college football athlete. Well, his father was the head of the football program at Oklahoma State University for many years. It's his son. He's 17. He was pled guilty or no contest to several counts of rape of a 17-year-old, two 17-year-old girls. One of them he almost killed with his choking. And the judge was going to sentence him to like 100 years and then said, oh, no, just counseling. So go back and watch that stream. It's from, I'll tell you exactly what it's from and exactly what it's called. Oh, the title of it is something like Oklahoma Horror Stories, No Contest, because both of those people in the thumbnail pled no contest in two horrific Oklahoma cases. One was Tiffany Adams, the grandmother, who with four of her buddies took the lives of Veronica Butler and Jillian Kelly. The other is of this horrific teen predator who is apparently just going to get off scot-free, except for we're making so much noise about it that there's a legislator involved in Oklahoma who may be doing something about it. So we'll see. But if you didn't watch that stream, go back and watch it. Mrs. Jim Marson is here. Says he usually oversees the search, you mean O'Hara, but Tully told him not to start until he arrived. I mean, he had the taillight, so it makes sense. Well, yeah. KBD says Tully said the car was en route, but it was in the Sallyport. Yes. Crushing capacity. Hopefully you're at a truck stop and not driving down the highway in your 18-wheeler, says McAlberts feel like they moved to Dresden with all the fires. McAlberts must feel like they moved to Dresden with all the fires. That's our 18-wheeler. Check him out. Check out that profile pic. He's smoking. He's in here all the time. He's an OG. He's been here for over a year. Not a lot of men here. I think we only have 20% male as far as subscribership goes, but the men that are here can hang. Man Switch Hunt says, I hope this implicates Tully so they can grab his phone if he hasn't already deleted his user account on Apple. Is it ever really gone, though? Is it ever really gone? New Cosgrove document just posted on Twitter. Aiden's case. Did you send it to me? Wait, is he recusing himself? Hold on. Megan sent it to me. Oh, you guys are so great. We've got it. We've got it. Hot off the press. You should never ever go anywhere. All right, crushing capacity is at the truck stop for a while. You should really never go anywhere when you're here because I can so easily pivot that every time something breaks, you guys send it to me and then we pick it up and it's like nothing ever happened. It's like we never miss a thing. All right. Here we go. Well, that one I have already. 3865. Wait. Oh, no, it's in Aiden Kearney's case. Okay, hold on. I think the other one was. All right, new Cosgrove filing in the Aiden Kearney 2020. This is a 23 case. He put the wrong index number on it. Or docket number, and then he had to change it. So thank you, KLM, for the hot tea, and it was already in my inbox. So look at us. Thank you for your super chat. Let's go there now. Here we go. This is by Robert Cosgrove, Cosy G, Cosy G. Filing this today, docket number 112 in the 2023 case. You see how they put the wrong index number in, and then they had to scratch it out and write the right one. So this is in the 2023 case, which is on behalf of at least, I don't know, 10 alleged victims of witness intimidation, including many of those whose houses were included in the rolling rally. Commonwealth versus Aiden Kearney. Commonwealth's motion for enlargement of time. And this is the redacted version for filing. Oh, I guess he needs more time I bet he needs more time to respond to the mega motion. That's just my guess. Okay. Now comes the Commonwealth and moves that this court enlarge the time for response to the defendant's filing, effectively constituting a motion to dismiss, right, the mega motion, from October 27th, because that's when his response was due, to November 17th, 2025. As reason, therefore, undersigned counsel represents as follows. Okay, let's see why. Why do you need more time, Kazi G? 1. On or about September 17th, 2025, the defendant filed an 87-page affidavit in support of his request for dismissal of the present case. Yeah, we know. We did all the hyperlinks too. It took us 15 hours to get through it in 3 different shows, but we did it. A 35-page memorandum of law in support of dismissal, and 3 approximately 55 exhibits in support of dismissal. I knew he was going to need more time. 2, at a hearing September 24th, 2025, this court set an agreed upon date for undersigned counsel to file a response of October 27th of 2024. I'm sorry, October 27th of 2025, which is this coming Monday, according to my math, because today is 24th. Since that time, undersigned counsel has worked diligently on preparing the Commonwealth's response, but has also been dealing with other matters, either directly or indirectly related to the present case. Right, like, should I recuse myself? Should I not? Don't I have a conflict? Don't I need to recuse myself? And if I don't recuse myself, am I going to get in trouble? But let me bill before I have to step away from this case. On September 29th, 2025, the defendant filed a supplemental affidavit and exhibits relative to the incident motion. On or about October 2nd of 2025, the defendant filed a 29-page motion arguing, among other things, inter alia, that the undersigned counsel should be disqualified from the present case. Oh, yes. Yes, they did. We've been through every single one of those filings, and aren't they just delicious? Hold on, I got to close this and open the next one for you. Isn't this fun? I can see you, Nina. I can see you, Nina. Undersigned counsel on October 8th of 2025 has appeared and argued in this court motions relative to the disposition of 2 telephones seized from Karen Reed. Oh, yes, we remember. Has, per order of this court, Judge Krupp conferred with Reed's counsel, since withdrawn, relative to a taint team search protocol, and has been served with a supplemental memorandum from the Reed team. Undersigned counsel has begun a written response to that memorandum. Wait, what do you mean since withdrawn? Did Buzang withdraw? I don't even know where to look for that case because it was filed under a search warrant number, but this is what it says. I'm going to read it again. If anybody has any clarification on that, let me know. Undersigned counsel, meaning Cosgrove, on October 8th, has appeared and argued in this court motions relative to the disposition of 2 telephones seized from Karen Reed. Right, in front of Judge Krupp. We were there. We watched it. Has, per order of this court, conferred with Reed's counsel. And then it says, since withdrawn. So did Buzang withdraw? I have questions. Relative to a taint team search protocol, right, because Krupp was like, you need to talk about the taint team. And Buzang was like, but, I want to still brief it, but. I don't know. And has been served with a supplemental memorandum from the Reed team. I don't know if we've seen that supplemental memorandum about the phones. Has anybody seen it yet? Hasn't landed in my inbox, but I'm going to have to go look for it now. Now I'm going to fall into another rabbit hole. Call me Alice. It's only 6 o'clock on Friday night. My girlfriend sent me a message earlier. She's like, I have free tickets to go see Little Feet tonight. Do you want to come? And I'm like, oh my God, I love Little Feet. Let's go. And also I love her. We went to see Yes together. But I was like, yeah, count me in. And then I go to look it up on Ticketmaster to see what time it starts. And I'm like, babe, it's tomorrow. Are you sure? So it's tomorrow. So I love Little Feet. And I thought I was going to go tonight, so I wasn't going to be able to hang out with you for that long. But since now I find out that Little Feet is really tomorrow, you know, fat man in the bathtub and all, I can hang out with you a little bit longer. Undersigned counsel has begun a written response to that memorandum. Okay, we're sorry that you have so much work, Kazi G, but you know, you're getting paid by the Commonwealth. And we know you tried to limit your bills, even though you worked like 1 million hours. You only charge for whatever the maximum of the month was, because we've seen your bills. And that's regarding a different case. So it's not an excuse to be like, Judge, I just have so much work. I can't get it done. Wah, wah, wah. Okay. Like that has nothing to do with this case. So you know what? This is a dumb argument, but this is what intrigues me here. Reed's counsel has since withdrawn. I don't know. Did somebody else take it over? Does anybody have any information on this for me? Because now I need to know. Hold on. Let's get out the red pen. Come to me, baby. Come to mama. It's not. Why is it not letting me mark it up? Oh, you know why? Because I think it's a JPEG. Hold on. Whatever. You see it, right? You see my cursor? It says since withdrawn. At the October 8 Reed cell phone hearing, Attorney Bradel appeared and sought to argue his October 2nd motion for disqualification of undersigned counsel, but was told by the court that it would not entertain the motion without giving the Commonwealth time to respond. The hearing was set for December 5th, 2025, right? The mega motion, December 5th. Many of the issues raised in counsel's latest attempt to have the present matter dismissed are based on grand jury and discovery issues that occurred during the time period where Attorney Kenneth Mello was acting as the sole prosecutor, sole special prosecutor. And then paragraph 9 is redacted, paragraph 10 is redacted, paragraph 11 is redacted, and then it says Mr. Mello, redacted, has located certain materials which he believes may be relevant and express mailed them to undersigned counsel, meaning me, Kazi G, on October 21 of 2025. Oh, so Mello is still participating here? They're using express mail instead of carrier pigeon? or fax? So there are materials that needed to be express mailed. I guess they're not documents because you could email documents, right? So what kind of materials would need to be express mailed? I mean, look, they're both of a certain generation. Maybe they don't know how to scan an email. Maybe it was just easier to send it by express mail, or what else could it be? 2 Dixie cups and some string. I mean, yeah, Mello was removed from the case, but apparently he still has, boxes full of information. He's got all the files that he never turned over to Cosgrove. So Mello and Proctor are the patsies, maybe. And you know who else? Berkowitz, because it's kind of easy to blame something on the dead guy, right? May he rest in peace, Kenny Berkowitz, the chief. But yeah, do you think they're going to try and pin it on the guy who's no longer among the living? Maybe it's a thumb drive. I don't know. Rubber ducks. Wrong answers only. Floppy disks. Yeah, maybe some floppy disks are coming by express mail. Reasonable time is necessary for undersigned counsel upon receipt of those materials to examine and evaluate them and consult with Mr. Mello and any other parties necessary as to any information gleaned therein. Well, I mean, maybe is he sending over his tablet? I mean, his stone tablet? Emily C. We'll get that joke. His stone tablet. The defendant will not be prejudiced by allowance of this motion. Telex would have been faster. Oh my gosh, you remember the Telex machine? XOXO, Robert C. Cosgrove. Love and kisses with extra hearts. Dated October 24th, 2025 today. I need more time. I need more time. I need more time because I got lots and lots and lots of work to do. And Karen reads phones and all the redacted stuff. But we did learn that instead of using carrier pigeon, Mello found some materials that are relevant and had to express mail them to Cosgrove on October 21st. Well, did you get them yet? Because today's the 24th. And what kind of express mail takes more than 3 days? It's Sanskrit. Nicole says it's in Sanskrit, so it's going to be a minute. Mimeograph copies. Yes, I do. The mimeograph copies. Remember the machine that they had to crank to get the dittos to come out? I mean, listen, it's only fair to give him like a little extra time. He doesn't have, a paralegal with a pencil skirt who hates him and can't even spell his name right. That's okay. We'll give him more time. It's in hieroglyphics, smoke signals, 2 soup cans and a string, maybe. Isn't Mello conflicted? How can he? Well, he was conflicted out of one of all, but he apparently still has a box of some kind of items that had to come by express mail. Like, why couldn't they just send Uber to get it? You can use Uber as your messenger now. You can have Uber go pick stuff up for you now. Like, it doesn't have to go to the mail. You can they can come pick up a box apparently now, and deliver it for you. Pony Express, Mitchell says. Pony Express. I mean, Marcello says, am I crazy? Because I remember Krupp being conflicted out of Aiden's case like a year and a half ago because he was buddies with former Judge Cosgrove. I don't know that. I don't know about that. I don't remember that. I do remember Judge Frenier conflicting herself out of hearing the issue about the federal materials because she was conflicted out because the guy that they hired was one of her mentors. I remember that. But I don't remember that. Does anybody else remember that? Is Marcello crazy? Smoke signals. Oh, you did? Wait, is Tedeschi Trucks opening for Little Feet? Because that would be awesome. Life-changing, says Stirred Not Shaken. I love Tedeschi Trucks. Love Susan Tedeschi so much. There's a box of assorted teeth. Yeah. Dr. Jenna Toxis says it was scrolls. Yes. Well, that's DoorDash does that for me. DoorDash goes to Home Depot for me. But you can have Uber go pick up a package for you and deliver it to you. Like the old fashioned, does anybody remember like the messenger services in New York City? Like you would call a messenger and the messenger would come to your New York City office and then the messenger would take like your envelope or whatever you needed delivered across New York City, like on a bicycle and like deliver it like in real time, like that same day. You never had to go to like the mailbox or anything. It was the best. Messenger services were the best. But yeah, that's DoorDash. DoorDash does go to Home Depot for me because I hate Home Depot and I just never know where anything is. And then I just don't like it. Cosgrove only accepts Pony Express, says Bob. Mello is still writing on the cave walls, says Dan. See, these are the guys who can hang in here. And Tom Gully too. The druids who do my deliveries are otherwise detained, right? Or an intern. I don't think he has an intern, Megan. Do you think? Yes, a courier. A courier. Be kinder than necessary. I like your username. I don't know why everyone is so mean right now on the internet. I don't know, except for you guys. We don't like the mean people. We don't let the mean people in. But Express Mail is so ridiculous. She says, why couldn't he have hired a courier? Right. Like the old-fashioned messengers. Courier companies still exist as well. Yep. I mean, Kazi can't be expected to do work in a timely manner, can he? Okay, we covered that earlier. Thank you again. And any good officer in here will tell you he definitely padded his stats. Arrests, he's dirty. On top, off, dirty. Thank you, on top. Leave the drama at the door, gifted a membership. Thank you so much. KLM says, new Cosgrove doc just posted on Twitter. We got it. We got it because I'm here for you. Sleepwatcher says, Melanie, I fell in love with your version of Law Tubes since mid-first Karen Reed. I have 3 sweatshirts so soft and cuddly. Enjoy a good coffee. Oh, that's awesome. Thank you so much for your 10. And also, where there is a sale in the merch shop today, the link is down below. So if you need anything like Christmas ornaments, we got them. Leave the drama at the door says, this is going to be the best movie. OMG. Yeah. I mean, it can't even, but I don't even think like it can be a movie. I think it needs to be like a multi-season series. I mean, really, because it's going to go on for years and years and years, in my opinion. And it can't just be told in 8 episodes. Like it needs to be like a good old fashioned season of SVU where there's 24 episodes, because there's so much story to tell. Thanks. Leave drama at the door. And Lauren says Proctor is going to make Furman look like a prince. Thanks for your super chat and your thoughts. On top says Cosgrove will be entering the nursing home about the same time Proctor enters the Hanoi Hilton. Good morning, Vietnam. Cosgrove likes to square dance with his lady, from what I hear. So I don't know. I don't know about that. Nina says, I love you, but I need a break. Your friend, the Glare, admitted on a live stream that he beaten his son, and now what? These are mean people. I'm sorry, Nina. You do need a break. I think you do need a break. I don't know about any of this. Whatever you're saying here right now is all news to me. I haven't watched any of this. Those were not even the mean people that I was talking about. So I don't know what you're talking about, but if you need a break, by all means, thank you for coming in and sharing your thoughts and paying me to share them. I'm talking about the mean people who, are over there on the Twitterverse. And Kimberly says, no, Glare did not say that. Yes, Kippy Hippie, we just went over the motion. Cosgrove needs more time. He needs more time to respond to the mega motion because he's very busy. He's a very busy man. He just got a whole bunch of stuff from Mello that he says could be relevant that had to be sent by express mail. So he still needs time to go through that. And then there was a great comment that flew by that said, oh, if it pushes the date past December 5th, does that mean it could go back to Doolin? Because maybe Krupp will rotate out. And the answer to that is, I don't know what their rotation schedule is. I don't know if Doolin is out for good. I do remember Doolin say, you might not see me here next time, but I don't know if that was because he was going to be on trial or because he was going to be in a different part. I do not know. And so I do not know. But that is something that is worth considering. And Susan C. gifted 5 memberships. Thank you so very much. Appreciate you so. This is the best Friday night ever, says Jackson's Nichols. Well, all those people are going to that Halloween party, so you guys are hanging out with me. Kristen, whatever you sent me came up blank. Oh, wait, now it didn't. Hold on. Right. There was something in the docket that Kate Peter posted the other day from December 5th that said hearing for appearance, appointment of counsel. Yeah, but I don't. Right. But then what had happened was they dismissed the charges for the 2024. It's very confusing. And so I don't want to guess at anything. I don't want to guess. Thank you, Lindsay. Would Karen Reed's team be notified of data from the phone even though she has been acquitted? They would have to request it in the civil suit to be able to get it. It would not automatically just be turned over. Could it be turned over, though, to law enforcement agencies that could be investigating the murder of John O'Keefe? That's a possibility. So no, her team would not automatically get that stuff turned over to them because that case is technically, the criminal case is technically over, right? Thank you, Lindsay, though, for your Venmo and your question, because it is a really good question. And some other people might also have that question. And Justin, thank you for the 10, says, old shows, but I really enjoyed Elementary and Leverage. We're talking about TV shows to watch earlier. Both are on Prime. Angelina Jolie's first husband, Johnny Lee Miller, is the star in Elementary with Lucy Liu. Oh, right. That was like a mystery show, right, Justin? Thank you for your Venmo. I think we've covered pretty much everything, right? That has dropped. Unless they decide to charge her with witness intimidation, that would be right. That would be automatic disclosure, right? But are they going to be able to search her phones? That remains to be seen. Like, I don't know what Krupp is going to do with that. But I'm curious about the part where they said that her counsel has since withdrawn, because I don't even know where to find that. Like, what docket number it's under. If anybody knows where those papers were filed, let me know. Oh, thank you also to Mrs. Goodman, who sent me a Venmo last night that I had to like ask her for help decoding. So thank you very much, Mrs. Goodman. The Goodmans are here. Yeah, the first step is that Cosgrove should either be removed or recused. And so he really shouldn't even be working on these papers, in my opinion. But maybe this will light a fire underneath Krupp to be like, oh, yeah, for all of the reasons herein, I'm going to grant this motion to recuse him. And then Cosgrove can stop working, because right now all he's doing is just billing the Commonwealth. Billing, right? Thanks, Kate. Yeah, Linda, why is Mello just hanging on to stuff that he's just handing over now? That's another great question, because we haven't seen him. We haven't seen proof of life on him since when? When was the last time anybody saw Mello on a hearing or even in person? Nunya says it was like he was telling them to be ready for trickery. Thanks, Kippy Hippie. No, you're the best. You're the best. Yes. Mama Deb says takes time to sharpen your quills, or his quills, right? It's Lisa. Lisa loved the smell of Ditto copies. Oh boy. Everyone have a blessed night, says D. Trauma-free zone. We try. I pulled that up without reading it first. So I can't verify anything that was in there. Thank you. Thank you, Marcello, for correcting yourself. Says, just found the video. It was not Krupp. My bad. It was 8/29/24. Per the Young Jerks YouTube channel, it was another judge that recused himself. Do you remember what the judge's name was? Because I don't. I don't remember. I don't remember. KPA said then the charges got dropped. It was incorrect. Microdots released a 2-minute trailer of Turtleboy's case. That's awesome. I can't play it because there's music in there that will probably get me striked. So everyone should go over to Microdots and watch it right after this. You know what? I'll even redirect you to it. So you don't even have to find it yourself. I will redirect you over there. So when we hit end on this, you'll be teleported over. All you got to do is just buckle your seatbelts. Thank you, Carrie, for becoming a new member. And Christine says, another song for Proctor, 3 Pigs by Pink Floyd. I don't know. Do we still have I don't even know if we still have the playlist even linked here. Pigs on the wing, says Bob. Thank you, Carrie. Kindergarten cop says, drop it now. Yeah, nobody should be able to. No, let's just, everyone just try and be nice to each other. Why can't we all just get along? Why can't we all just get along? Best way to spend a Friday night. All right, let me see if I can do that for you so that it'll make it so much easier for you. Is there any more breaking news? What more could possibly break while we're here? I mean, I'm sure I'll see you over the weekend because I'm sure there's going to be lots of stuff happening. Let's see. Oh, Richie, how do you not have it set up? Isn't the name of Microdot's channel just Microdots? Or is it called something else? Somebody give me like the full on. Are you heading over to Turtleboy's Halloween party? That's awesome. Kelly, Chloe Bit, so we must have quit. You're going to the potty? You going to the potty? Don't take any pictures. It should be like Soho House where you have to leave your phone in a bowl. Microdots clips. No. He doesn't allow redirection, so some people don't. They don't even know. Some people don't even know that they can. So it's just not there. Oh, I know what we could do. I know ways I could send you. Hang on. I'm going to send you over to my girl, Andrea Burkhart, because, you know, who doesn't love a little Andrea Burkhart? And you can learn about her kitten journey. And she's doing a show right now on Charlie Kirk. I mean, on, you know, the defendant in the Charlie Kirk case. And she's wicked smart. She's wicked smart. Hang on. Because, you know, you should do like a cupcake invasion over there. Because it just started, let's say, it started an hour ago. All right, we'll do that. Because that we love to love. We love to love the people that we love. And I love Andrea Burkhart and her husband, Jeff. He's awesome. So she's only got 750 people watching. So I'm sending all 3,600 of you over there. Tell my girl that I said hi. I don't know if I have the energy to watch anybody else's show right now, but I do love her with all of my heart. And if I don't see you soon, I'm going to die. Coastal Rob, I'm gonna link. You know what? I'll do it right now while I'm in the chat. While I'm in here, I will link the earrings that you asked for to this stream. The link will be there so that you can get right on over there and get them for your girl. Hold on. Wait a minute. Products. All right. They let me do this now. And you guys are like always like, what's that lipstick? What's your... And so here's the earrings. And now they are linked to the stream. And also, you know what I'll link for you also, because I'm a giver and also I love to share secrets, is the Wonder Skin color that I'm wearing today. Well, also the Rare Beauty Luminizer, you should also, that I have on. And you guys say, oh, you're so glowy. That's why. And the All Day Lip Stain, which is not all day because I've been talking way too long, is also linked. Enjoy. Enjoy. All right, you guys, buckle up your seatbelts because I'm going to send you over to Andrea Burkhart for a cupcake invasion, and you're all the best, and I will see you all real soon. Except for, Hold My Halo says, check out the Wood Brothers. They played with Tedeschi trucks. You will love them. Thank you very much. I will check them out. And Danny says, plan to sew, listen, and relax today. Ended up replacing the drain pump on the washer. It worked. Thank you for spending your time doing this. Listen, Danny, anything you need to fix, there's always a video on YouTube to teach you how to do it. I once learned how to refire my own oil burner by YouTube video, and I've saved it so that if that ever happens again, I will be able to do it. Okay? Love you guys with all my heart. Get on over there and give Andrea Burkhart some love. In 3, do all the things though. First, smash the like button. On your way out here, comment respectfully, share the stream, and do the hype thing. You can hype this video somehow with points. I don't know how you do it, but it says hype this video. Get on over and do it. Love you guys. See you real soon. Bye. Thanks, mods. I love you.